Good morning. Buenas and Hafa Day. The Committee on Environment, Revenue and Taxation, Labor Procurement, Statistics, Research, and Planning is calling this public hearing to order. It is now 9:03 a.m., Thursday, February 23rd, 2023. In compliance with open government law, notices of this morning's hearing were published in the Guam Daily Post and provided via email to senators, stakeholders, and the local media, and posted to the Government of Guam Public Notices website on Thursday, February 16th, 2023 for the 5-day notice, and Tuesday, February 21st for the 48-hour notice. I'd like to acknowledge my colleagues that are here today: Senator Jesse Lujan, Senator Chris Barnett, and Senator Tom Fisher. Good morning. Good morning. Thank you for joining me. The purpose of this virtual public hearing is to receive testimony on several agenda items. The first one is Bill number 36-37 COR, sponsored by myself, Senator Sabina Flores Perez, Senators Chris Barnett, Roy Quinata, Joanne Brown, William Parkinson, Jesse Lujan, and Joe S. Agustin. It's an act to add a new section 5428 to subarticle A, Article 9, Chapter 5, Division 1, Title 5, Guam Code Annotated, relative to administrative review of the critical government of Guam procurement contract decisions generally in excess of $5 million. The second item is Bill number 45-37 COR, sponsored by myself, Senator Sabina Flores Perez. It's an act to amend Section 5230 of Chapter 5, Title 5, Guam Code Annotated, relative to clarifying the process for determination of responsibility of bidders and offerors in procurement. The third item on the agenda is Bill number 46-37 COR, sponsored by myself, Senator Sabina Flores Perez, and Senator Chris Barnett. It's an act to add a new Section 5425.2 to Part A of Article 9 of Chapter 5, Title 5, Guam Code Annotated, relative to providing temporary expedited procurement protest procedures for acquisitions funded with the American Rescue Plan Act, monies allotted to the Guam Department of Education. And finally, Bill number 8-37 COR, sponsored by Senator Jesse Lujan. It's an act to add a new Section 5221 to subarticle B of Article 3, Chapter 5, Title 5, Guam Code Annotated, ensuring the online accessibility and timely posting of any and all Government of Guam invitation for bids and requests for proposals on a dedicated government website. So the rules of conduct of today's hearing includes that those who are called to testify will be in order, beginning with those who called in advance on February 17th, followed by those on the sign-up sheet. Individuals testifying shall first be recognized by the chair before speaking, and begin by stating your name, organization, position for record-keeping purposes. Senators will be given the opportunity at the end of each panel to ask questions, and questions and testimonies shall be confined to the substance and nature of the agenda. Now to begin our agenda, Bill number 36-37 COR, sponsored by myself, Senator Sabina Flores Perez, and Senators Chris Barnett, Roy Quinata, Joanne Brown, William Parkinson, Jesse Lujan, Joe S. Agustin. It's an act to add a new Section 5428 to subarticle A, Article 9, Chapter 5, Division 1, Title 5, Guam Code Annotated, relative to the administrative review of critical Government of Guam procurement contract decisions, generally in excess of $5 million. I'd like to provide a brief introduction. Bill 36-37, again, co-sponsored by Senators Chris Barnett, Roy Quinata, Joanne Brown, William Parkinson, Jesse Lujan, and Joe S. Agustin, is one of two bills on today's agenda that aims to provide expedited procedures to resolve protests. Bill 36-37 proposes to expedite protests specifically for critical procurement contracts. In order to qualify as a critical procurement contract, all of the following criteria must be met. The solicitation is one in which is integral to the timing of the planning, development, construction, financing, or completion of major public infrastructure, and 2, is reasonably likely to cost in excess of $5 million. 3, the identified funding or the required labor available, site or required materials for the critical procurement contract is restricted or becomes restricted to the material detriment the procuring agency or other agencies having a stake in the project, or the timely contract performance by a territorial or federal entity, law, or regulation. Bill 36-37 proposes that critical procurement contracts must be designated as such by the procuring agency or upon protest and ratification by the governor no later than a week after the contract is awarded. Bill 36-37 would require the public auditor to expedite the administrative review process of the final appeal in accordance with the rules and regulations to be adopted and promulgated by the public auditor within 6 months. of the effective date of the proposed legislation. Additionally, the bill proposes if the protest is challenged in courts, that it takes precedence in the court docket, except cases that the court considers of greater importance. It authorizes the court to assess attorney fees and litigation costs in which the complainant has substantially prevailed. So although protests are an essential part of the procurement process, Bill 36-37 was created in response to concerns of the delay and inability to accomplish capital improvement projects due to lengthy protests with a potential added challenge of looming expiration of federal funding, which currently includes the American Rescue Plan Act, the Infrastructure and Jobs Act, the Inflation Reduction Act, which provides much-needed funding for deferred capital improvement projects. Bill 36-37 proposes to codify the expedited process to alleviate delays due to protests that can stall much-needed capital improvement projects for current and future needs. I would like to thank my colleagues for their support, and I look forward to the ensuing discussion and testimony. Just for the record, notices were sent to Department of Administration Director Edward Byrne, Director of Department of Public Works Vince Areola, the Chairman of the Guam Contractors Licensing Board, Mr. Bernard Beneventi, Acting Superintendent of the Guam Department of Education, Judy Wampat, GSA's Chief Procurement Officer, Claudia Fadzi, the Public Auditor, BJ Cruz. It's nice to see many of you here today. Thank you. We received a fiscal note February 16th on 2023 from BBMR. It states the proposed legislation intends a new category as the critical procurement contracts, which involves procurement that is reasonably likely to cost in excess of $5 million and details the process for the administrative review and judicial appeal of critical procurement decisions and final appeal being brought to the public auditor and the judicial proceedings authorized in the proposed legislation. The passage of Bill number 36-37 required the public auditor to expedite the administrative review process of the final appeal in accordance with rules and regulations to be adopted and promulgated by the public auditor within 6 months of the effective date. Although the proposed bill appears to be administrative in nature, absent additional information from the Office of Public Accountability, the Bureau is unable to determine the fiscal impact that the bill may have on OPA and its operations. The committee has received written testimony from the public auditor, as well as Guam Power Authority, and also we received testimony from students from the Guam Community College Module 1 Procurement's Basic Training, Fundamentals and Principles class of January to February 2023. At this time, I would like to call upon the public auditor, BJ Cruz, to come to the table, Director Byrne from Department of Administration, Attorney Brown, GPA, Attorney Graham Botha, also Attorney Anthony Camacho to come to the table, and if there's anybody else who would like to proceed to come to the table for any testimony. Is there a representative from Guam Department of Education as well, who is here to provide testimony on Bill 36-37? Okay. All right, thank you. We will now proceed. I'd like to recognize Public Auditor Benjamin Cruz.
Hofty and good morning, Madam Chair and esteemed senators of the committee. Thank you for the opportunity to provide testimony on Bill 36-37. The Guam Office of Public Accountability supports the bill. However, we recommend that the critical procurement contract should be designated at the start of the procurement solicitation and should be done by the Governor of Guam and the Attorney General of Guam, not the procuring agency. It should be clearly stated in the procurement solicitation that it is a critical procurement and that any protest relative to the procurement will be treated in a special expedited process. All prospective bidders of the procurement must acknowledge and sign off that they are aware of and will abide by the special expedited process. In addition, the OPE can and will develop and promulgate the rules and regulations of this within 90 days only to comply with the Administrative Adjudication Act. But if this legislature deems fit to give us special authority to issue it in a shorter period, we can issue it in a shorter period. The 6 months is not unnecessary. We need to get this done, and our office stands ready to assist. So whatever power you give us, we will. And we are honored by you wanting us included, but the thing is that it should be done before the first bid is published. The acknowledgement. Section B needs to completely be dropped in your bill, and it should clearly state that it should be so designated by the governor and the Attorney General. The Attorney General is involved in all procurement contracts over $500,000 anyway, currently, so they should know, and their involvement should be able to move this further. But that designation has to be there, stamped in 30 bold font print on the front of the bid package that this is critical procurement, and they're going to acknowledge that there's an expedited process. Thank you.
Suzus Masi, Public Auditor. So we'll continue with the testimonies, and then we'll have questions for the panel. So I'd like to recognize Director Byrne.
Good morning, Madam Chairman, Senators. Thank you for inviting me to this hearing today. It's my first of this legislature, and I suspect the first of many. Department of Administration supports an overall update to procurement practices by the government of Guam. The current legislation is based upon the Model Procurement Code, which basically is 2010 legislation or draft legislation. And I don't think anybody could argue that conditions haven't significantly changed since 2010. We're operating in a completely different commercial market, and we have to meet completely different conditions. Bill 3637 recognizes this problem, and therefore DOA supports it. The problem actually is fairly widespread in that we are dealing with not only changing conditions since 2010, but changing conditions during the course of a procurement. And if a procurement takes a long time, and this bill is designed to shorten that time, but if a procurement takes a long time, often conditions change during the course of that procurement. That leads to changes in specs, sometimes having to withdraw and reissue the solicitation. So the process of shortening that and simplifying that is certainly a good process to follow. The concern, I think, that DOA has, that it appears that this bill is targeted only at infrastructure. We've just been through a lengthy procurement for the new FMIS system. We're all kind of bruised and blooded as a result of that. But we got through it, and we now have the contract. But I would certainly recommend that significant service contracts are also included into the bill, for they tend to hold up the whole process as well. DOA agrees with the public auditor that the identification of these procurements should be made at the solicitation stage. It's important that the potential bidders understand the process right at the very beginning, and it's even more important that the procuring agencies also understand and have taken on board the reasons for needing to invoke this particular part of what will be the legislation. The timing that the public auditor referred to is also something that DOA would like to support and look at. During the course of this fiscal year, I anticipate there's going to be many significant procurements that, under current legislation, could possibly be delayed and held up. So I agree, we want to move any procurement through this process as quickly as possible. Many of the projects that are possible under the infrastructure bill that you mentioned are competitive. And we might be in the position of competing not only with other territories, but other states for funding for some of these projects. And that argues also for speed, for we don't want to be seen to be holding up procurements. That will not put us in a very good competitive position. So I would certainly support anything we can do to move these large, and the infrastructure projects will be large, these large procurements through the system. Thank you.
Thank you so much, Director Byrne, for your testimony. If you could stay for questions, thank you. And I'd like to recognize Attorney John Brown. Thank you for being here.
Thank you, Madam Chair and Senators. I heard a couple of comments, and I don't disagree with these gentlemen generally, but they say that it needs to be identified in the solicitation, that this is a special kind of a contract. And Section B in 5428, the bill does state that a critical procurement contract shall be designated as such by the procuring agency in the solicitation. I think that it gets that identity, but if it doesn't meet with you, we're all on the same table. It needs to be broadcast, it needs to be advertised. But it was contemplated in the bill. Other than that, I agree with everything that I've heard so far about the necessity for having this sort of a thing. The only, my concern is that it's going to go further than it would be helpful to go further. Everybody's going to want to do it this way. They're not going to want to go through the procurement protest method, because this basically escapes that agency level review, and that could get burdensome after a while. So that's just my comment on that. Otherwise, it seems to me to be a well thought out bill, but perhaps not thought out well enough. Just as long as we just don't overdo it. Thank you.
All right, thank you, Attorney Brown. Again, we'll ask questions after testimony is provided. I do recognize Acting Superintendent Judy Wampet. Thank you for being here. I'll just, would you like to provide testimony? Yes.
It's in the 36.
You're recognized.
Half-a-day senators. It's just really short. I'll just say that DOE supports the intent of the bill, as it would ensure that critical procurement contracts are not stymied by the automatic stay requirement of the law. However, DOE would suggest that the definition of critical procurement contracts include contracts that would involve critical services that may not be at the amount of $5 million, but are critical for the operations of any agency or critical to the maintenance of a safe work environment. Thank you.
All right, thank you, Acting Superintendent. I'd like to recognize Legal Counsel, GPA, Graham Botha, for his testimony.
Thank you. Half-a-day senators, thank you for the opportunity to provide testimony in support of Bill 3637. Guam Power Authority supports and agrees with the stated intent of Bill 36 to strike a balance of strengthening local procurement through the protest process and acquiring much-needed critical procurement contract to meet the needs of our community. While the current procurement protest process preserves the rights of aggrieved bidders to dispute a government decision regarding a contract, it may do so in some cases to the detriment of the utility ratepayers. At least one recent protest underscores this unintended negative consequences to the ratepayers, resulting from a renewable energy generation energy storage bid. GPA issued an award for 50 megawatts of solar photovoltaic energy generation and a full shifting battery storage system. An unsuccessful bidder appealed to the Office of Public Accountability, and within 3 months of hearing the appeal, the OPA issued its decision in denying the appeal. The bidder then exercised its right to continue its appeal in civil court, and approximately 16 months later, the court affirmed the OPA's decision, finding GPA did not violate Guam's procurement laws. GPA attempted to reinstate the award. However, the successful bidder refused the original project pricing, arguing that prices had increased after the 2 years that elapsed since the initial award. The unsuccessful bidder and appellant were not the only losers in this case. The utility and its ratepayers also lost. GPA lost the opportunity to gain progress on its renewable portfolio standard and consent decree milestones. All ratepayers lost out on significant savings from this clean renewable energy contract. At the current LEAC rate of approximately 31 cents per kilowatt hour, this loss is calculated at approximately $17 million annually, and GPA finds such an outcome unconscionable. Concerning the proposed new Section 5428B, GPA respectfully requests the following amendment. B, a critical procurement contract shall be designated such by the procuring agency in the solicitation for the contract or upon any protest brought in accordance with sub-article A of this article, and such designation is ratified by the governor. We've requested additional language or governing body no later than 1 week after the contract is awarded. The Consolidated Commission on Utilities, CCU, is GPA's governing body, including for certain procurement matters, and as such would be the appropriate body authority to ratify the designation of a GPA critical procurement contract. We are heartened that the sponsors of this legislation are committed to finding a much-needed balance between the procurement process protest and the island community's needs. We believe that Bill 3637 offers a fair solution and offer our full support. Thank you for the opportunity to provide testimony.
All right, thank you so much, Attorney Botha. I'd like to recognize Attorney Anthony Camacho for his testimony.
Good morning, Senators. Good morning, Chairperson. Oh, hopefully I'm not that loud here. I didn't know that putting it this close would have that effect. Sorry. So just to be brief, essentially, it's my view that the complaints about the process taking too long, that's just a symptom. The real reason these protracted procurement reviews that result from protests really hurt the people of Guam is the automatic stay, and specifically the automatic stay that's imposed by 5 GCA Section 5425G and 2 GAR Division 4 Section 9101E. Currently, whenever a protester files a protest before the award, the automatic stay applies, and the automatic stay is imposed until the final resolution of the protest. The Supreme Court of Guam has ruled that that automatic stay lasts all the way until the Superior Court of Guam issues a decision on a protest appeal from an OPA decision. If the protester wants the automatic or wants to appeal to the Supreme Court and wants the automatic stay to continue, they have to apply, just like every other party, for stay pending the Supreme Court of Guam's review of their actions. So that's where it ends. The issue we're having really is the fact that if we look at the OPA's hearing process, it is an expedited process. If you were to review it and you added up all the timelines, really within about a 30 or so day period, the OPA could hear or hold a hearing on the protest appeal to it. Within 30 days after the conclusion of that hearing, essentially the OPA would have to issue a decision on the appeal. So that's a fairly quick process. We're talking about typically, my experience, and I have well over a decade of experience both going before the OPA as a party and serving as a hearing officer. It takes about anywhere from usually about 60, perhaps 70 days to get a decision from the OPA. Yes, there are some cases that might take longer. This is where the hearings stretch out for weeks, perhaps, or there might be motions that come before the OPA. But typically, we're looking at only about perhaps a 3-month period at the most for an OPA appeal. The real delay, once again, is the Superior Court of Guam, which might take anywhere up to a year and a half to decide the case. So would expediting or passing this bill, saying that we have to hear this, will that make the process any quicker? Probably not before the Superior Court of Guam. There's a backlog of cases. Even an asserted criminal trial takes an enormously amount of time to get through the court. Hence, the real cause is this automatic stay. Yes, it does serve a purpose. It does ensure that the protesters' protest gets reviewed and perhaps even appealed to the OPA before it's decided, before the procurement proceeds. But remember, the supplies and services that are solicited are for the people of Guam. Think of a child in GDOE sitting at a cafeteria eating lunch. Everything from the very chair she sits on, to the table the food is put on, to the food itself, to the electricity in the room, to the water, it's all procured. It all goes through this process. And when we have a stay that exists for a protracted period, the people of Guam are being denied the supplies and services that they need. So that's a real issue. It does serve a purpose, but where's the balance? Well, I think the balance really is at what point does the automatic stay no longer become automatic? And I think that point should be after the OPA issues his decision. Essentially, if they're going to appeal to the Superior Court of Guam, every other party has to go before the court. If they're seeking injunctive relief, they have to file a motion. I want to stay, or I want a temporary injunction. The party in whom the injunctive relief is directed has a right to come in and say, well, I got this, temporary injunction, or I got this no contact stay away order. I don't think the court should impose this on me because, and the court would have to hear that argument and then decide. Likewise, that should apply to a protester going before the court, because what the automatic stay really is injunctive relief. It's prohibiting the purchasing agency from taking further action until somebody decides the case. And so why should we give the protester that much power when everybody else going before the Superior Court has to apply for it? And that's the point I think that, or that's the thing that I believe is a simple change. That's a change that would not only basically, with that simple change, you wouldn't have to expedite proceedings. Like, once again, the OPA is pretty much an expedited proceeding now. The Superior Court, they're going to do whatever that third branch of government is going to do, and they do take long doing it, period. That's the historical record. So I think that I am supporting the bill. Even if this is all there is that passes, at least it's a step in that direction. That's why I support it. Further, I do want to point out something in the language of the bill, though, that does concern me. So on the page 3, lines 9 to 10, where it talks about the automatic stay, it says, "There shall be no stay unless ordered by the public auditor of an awarded critical procurement contract." I submit that this particular language is troubling. If the intent is that there is no stay unless ordered by the public auditor, it would only apply to a small number of contracts. Here's why. Currently, the automatic stay only applies to a protest filed before the award of a contract. That's the majority of protests. 90% of them are going to be pre-award. Why? Because they all know that if you file an award or you file your protest after the award is made, the automatic stay doesn't apply. Here, you're actually expanding the ability of a party to get an automatic stay at the OPA level instead of kind of restricting it and making the OPA determine it. Further, like I said, you're only reaching 10% perhaps of the protest. That's a small number because the vast majority will be made pre-award of the contract. And on those grounds, I think that if you change the automatic stay and you limit it just to the point where the OPA makes its decision, you have a second bill concerning GDOE that might actually address that issue as well. Thank you.
Thank you so much, Attorney Camacho. I really appreciate those points for consideration. And you're right, as far as balancing, I think the automatic stay is really a critical component in addressing these delays. So I just, some things that were brought up in the testimony, I just want to maybe get a consensus or response to. So I guess one of the changes that was proposed was that I agree that if it's a critical procurement contract, it should be upfront. I think that's really important for the offerors, bidders to know that they're dealing with a critical procurement contract and that they'll be dealing with expedited protest procedures. I guess the question now for everyone here is who should be the deciding and why deciding authority of a critical procurement contract? Obviously, the procuring agency should decide that or not. So I guess maybe if we can explain that a little bit more. We understand your view. Or maybe you can expound on that, Public Auditor.
The reason why I hesitate in leaving it with a procuring agency is that there may be self-interest in the part of the agency to, as one of the other testifiers mentioned, this may be the way that everybody's going to want to go by just claiming procuring contract. The reason why I suggested that it be the governor and the attorney general is not because I think that the governor has some wealth of knowledge about procurement, but the governor has, in this term at least, this governor has finally established the Procurement Policy Council, or office, and they could advise her that this is something that is of a critical nature. And it wouldn't be self-interest. It would be the agency, DOE, could come in and say, I need to do this as a critical contract, procurement contract, and come to the policy office and explain why they're doing it. And the policy office will make the recommendation to the governor, this should be signed off. And as to, and the Attorney General is involved in the whole process because of the size of the contract anyway, so they should sign off on it. And I agree with Mr. Camacho that we do try to expedite the appeals that come before us. We have a timeline for it, and usually the main problem is the procurement record. And if the AG is involved, they should know that if this is a procurement, critical procurement contract, and it's going to be an expedited process, they better be keeping the procurement record contemporaneous, I mean, up on a daily basis, so that upon the filing of an appeal, that you can have the procurement record in the office within 1 day, within 2 days, rather than 5 and then asking for an extension because we're still trying to gather it together. That record should be kept on a daily basis, though I can't testify to it, but sometimes the delay makes me think they haven't been keeping it together. If they can't give it to me immediately, then it wasn't ready. And so even giving them 5 days. But the other thing that I wanted to point out, and I hate to disagree with my professor and my guru and mentor, but B does have an or, which is I think where the problem that I have. Yes, it does say agency in the solicitation of contract or upon any protest, that really has to be struck. You can't be changing and saying, oh, on second thought, this is a critical procurement contract when I filed my protest. It should be up front. There's none of this. And 7 days later, the governor has to ratify within a week. The governor should designate this as a procurement contract 7 days before it goes out to bid, not 7 days after it's protested.
Okay, so what about flexibility? I mean, I think the procuring agency should know that it is critical to their needs, and
that's why I think when they write it up, they can make their appeal, as it were, or their request to the policy office to recommend that the governor do it. I'm just trying to make it so that it's a complete third party from the procuring agency, because in one of your other bills you have the OPA being the designator, and though I'm honored by the confidence that you show, it really would impair my ability to be able to hear the hearing if I'm the one that says this is going to be a critical procurement contract, or this is going to be an arrow. It should be somebody else than the person that's hearing it. I mean, I wanted a third party, but if the legislature decides a procuring agency, that's fine with us. I just don't want the or upon protest. I mean, that's just going to make for more trouble than I want to have to deal with.
yeah, so I apologize, we didn't send a notice for the Attorney General to be here, but we'll definitely reach out to him in regards to some of these recommendations. Yes, Acting Acting Superintendent.
Thank you. To a degree, again, I agree with my colleague here. My concern about I like the third party, I don't mind it. My concern is, at least with recent events that has happened at the AG's office, I'm really going to see a bottleneck of any of these procurements being reviewed and then sent back to the procuring agencies. So I would, if you are going to go that route, then please put some timelines, so that then it does not sit, for a long period of time. And because in my earlier statement, I did request that critical contracts actually be considered, and because of how we operate, it's always in the best interest for the health and safety of our children. And some of those contracts actually are smaller that would then benefit, from this if you include those critical, and smaller contracts. And I'll just give you an example, like our custodial and janitorial contracts. That's what I'm specifically speaking to. And it's not, of course, at $5 million. Thank you.
All right. Yes, I appreciate that comment. Perhaps in consultation, so maybe procuring agency in consultation with some expert, I think might be a good potential amendment. Okay.
Mr. Burns is the chairman of the council, of the policy office, if you want to talk.
Senator, could I address that point too?
Oh, sure.
I agree with the public auditor that we want to, and I've spoken to Attorney Brown about it, the or in that wording is confusing. I believe we should know at the beginning of the solicitation exactly the status of this, so that the procuring agency frames the whole procurement around that. There are many practical reasons why you would want to start out a procurement having made that declaration, and I strongly recommend that we do that.
Okay. So, I have to go back through the law, but I believe the policy office is there for regulations. So I know they're not supposed to get involved in procurement issues, so there has to be perhaps a different body that does that. Yes, Attorney Camacho.
Yes, going to the issue of whether it should be the agencies or the governor that determines whether or not it's a critical procurement. Please bear in mind that not all agencies are the same. Where the language purchasing agency makes that determination, where that's really valid is the purchasing agencies that are not part of the centralized procurement regime. That's a regime set up by Article 2 of Guam procurement law. Basically, GSA serves as the general services agency for the executive line departments and several other agencies in the executive branch. However, University of Guam, to which I'm general counsel, yes, and basically GDOE, GMH, GCC, basically all of these agencies are exempt from Article 2, the centralized procurement regime. And the reason for that is you're talking about agencies that have, number one, very massive procurement. In the case of GDOE, they probably are one of the largest procurers of items in all of Guam because of their student population. So essentially there's a reason why they're exempt, so they can expedite their own procurement. So these bottlenecks won't get created. Here, requiring them to go through the governor and the agency's office would in effect be a bottleneck and severely curtail at least the educational operations and as well as our health operations at GMH if these bottlenecks were allowed to be created in the first place. Hence, I agree that purchasing agencies should be there, but if you wanted to limit that, just to make sure that the executive agencies weren't, the rest of the line agencies weren't included, you could just have those agencies that are not defined as governmental bodies. Those are the ones I've already stated, GMH, UOG, GCC, GDOE, and UOG basically be the purchasing agencies allowed to make their own determinations. And keep in mind, in the case of at least GDOE, it is an elected board that runs and decides things on GDOE's behalf. Thank you.
Thank you for that clarification, and I believe that was what Attorney Botha had in his testimony, so I think it definitely reinforces that. I'd like to recognize my colleagues. My apologies for the delay that have joined me here today, Senator Tello-Taitigui, Senator Joanne Brown, and Senator Quinata. All right. Okay, thank you. We'll definitely work on the language for that one, just to kind of, I like all the points that are being made. Is there anyone else that would like to add to this? Attorney Brown?
Yeah, I'm concerned again about this getting confused, because we tried to find objective criteria, not, well, this is important to the safety of the kids. What does that mean? Where are those limits? And that could end up eating the whole, this is meant to be an exception. It will swallow the exception if you let it. So we need to have objective criteria, not subjective criteria, in determining what this contract is supposed, this particular contract is going to look like. How do you identify it?
So I believe, thank you for that comment. I think the public auditor would, the rules and regs that are going to be developed should hopefully have those objective criteria or basically expedited process.
Well, that would be just the expedited process, but the determination really has to be made by you guys. I mean, you guys have to say what the determination is. Who's going to be the subjective determinator, if there's such a thing?
Okay.
Determiner.
So then I guess it then leads back to the policy office to come up with those criteria, right? Okay, thank you. All right, the other point is, so another point of amendment was expanding it beyond infrastructure and so automation. I think that is, I guess, maybe the language could be capital improvement projects versus just infrastructure. But then again, yeah, I mean, the services, I mean, that's something we can look at as far as language is concerned. All right. Okay, The other important point that was brought up was the stay. And so I really appreciate the points that were made by Attorney Camacho, that it's the stay that really is what impacts the protest. And that I think that provides a good balance. There was some mention that, the judicial process, we have a limitation as far as what can be mandated to the judiciary by the legislature, if any, right? So the injunctive relief, the automatic stay is removed after the decision. I think that's a good amendment. I just maybe would like to have maybe the feedback from the rest of the panel, if there's anything that they can illuminate on that. Public Auditor?
I would support that upon our decision that the stay is dissolved. I agree with Mr. Camacho. I'm not sure if you want to be giving us the authority to impose a stay at that point.
Then in regards to the timeline, so he'd mentioned the practicality of resolving an appeal actually goes beyond the 20 days in this bill. So does language need to be included to give it more flexibility?
No, we can get the decision out within 20 days. Mr. Camacho was there and issued a very good decision on one of the cases where I think he did it within 10, 11. Because when we get to the other bill on ARA, the office is capable of moving protest appeals through in a very expedited fashion. And during the early teens, 20 teens, when Mr. Camacho was a hearing officer at the OPA, they dealt with a number of cases where they were able to get cases out with just after 10 days, under 15 days.
Okay, and is that like the average, or what's the high end?
Right now, the way that we have it is within 5 days you have to do your record on, procurement record has to be provided. Then there's time for the agency response, and then motions within 30 days, and then this reply for the motions, and it's a hearing for the motions. During the expedited period, I think my staff and I were discussing it, and we could it could be as easy as upon the filing of the appeal in our office, within a day, and at most 2, because that record on appeal should be contemporaneously prepared. Within 2 days, that should be filed with the OPA. And the agency could probably, within 2 days, also provide its agency response. By the 5th day or the 6th day, you could have the first set of motions, and then 3 days later, or 3 or 2 days later, the reply, and then the hearing by the 10th day. The decision could be out before the 15th day.
Okay, well, thank you.
And we'd be willing, we talked about it, we'd be willing to move that
Okay, I appreciate
if
that.
it happens.
Thank you so much for that clarity.
Hopefully it doesn't happen if, and I'm glad that they're finally starting to do the classes stuff, if everybody who is involved in procurement gets trained. Because the thing that delays things is when people don't have certification.
Yes, appreciate it. Then I believe that was your bill, right? So thank you for that. And
Yep.
it's good to see that. Thank you, Attorney Brown, for volunteering.
One more comment on the automatic stay.
Okay.
It's there to protect the shenanigans that the agencies used to do and would do again, but for enforcing that stay. They used to award the contract, and then notify everybody else, and it's too late for them to protest because the stay kicks in. And we managed to change this so that the process, so that that doesn't happen anymore, but it'll go right back to it. And there is also a built-in means of lifting that stay in that same automatic stay clause or section. So yes, the automatic stay is a source of a lot of grief, but there are other ways to curtail the grief besides just doing away with the automatic stay. It has a place.
Okay. So what is your thoughts about lifting it after OPA comes to a decision?
I have no problem with it.
Okay.
It's the agency level
Okay.
that this happens, because once it goes into effect, it goes into effect, because at this point, the public auditor doesn't have the authority to lift the stay. So, I mean, I wouldn't mind that if, once it was appealed to the public, but you got to be able to get a protest in. and if you've already awarded the contract, that stops all protests. We need a bit of work on that in a separate bill, I would think.
Yes, definitely. All right, so thank you for your, answering the question. Does anybody else, Attorney Camacho?
Yeah, just real quick. So the, basically, in terms of what Mr. Brown is referring to is it used to be a common practice that, okay, I'm going to have to, and just so you know, if an award is made, that will not stop a protest. You can still protest. It just limits the relief you can receive. If you prevail, the award could be removed, or essentially you could be awarded your costs for the appeal, as well as for your bid preparation costs, so on and so forth. So it really just limits the award. It doesn't prevent you from making a protest. In terms of, and what Mr. Brown was referring to is this practice of, okay, so what we're going to do is we're going to announce the award today. And we're just going to award it, okay? There's supposed to be a 14-day period that the protester has to file the protest. What a lot of agencies would do is just award it, and then it would only be post-award relief that a protester could seek. There is a Supreme Court case. I want to say it's PDS versus, it might be GCC or GDOE. It's at least close to 6-7 years now old, where the Supreme Court of Guam has already ruled that the agency cannot make that award within that protest period, that they actually have to wait for its expiration. Otherwise, it would nullify their right to protest. So I believe that the court has already resolved that issue. If the legislature wants to codify that, I suggested look at that case because it was very well articulated in terms of the relief that the Supreme Court gave to the protester. Thank you.
Thank you so much, Attorney Camacho. So I'd like to open the floor to my colleagues. Senator Lujan, if you have any questions for the panel.
Thank you, Madam Chair. Welcome, panel. Public Auditor, you had mentioned the fact that you wanted to strike out, I think, Section B there in its totality and leave it up to I guess, the Governor's Office or the Attorney General to proclaim as such the critical nature of such. Are you saying that in regards because everything else will be labeled critical in nature? And
Well, my wanting to strike B is just after the or.
okay,
It's a solicitation. As long as it's stated up front, and I wasn't being facetious when I said in 30 bold print at the top, this is a critical procurement contract, and everybody who's going to, I would like to see that everybody has to sign an affidavit. I acknowledge that this is a critical procurement contract, and I will abide by the rules of the appeals process in this. when I'm going to submit my bid. You know, as long as everybody knows the rules up front, it cannot be with this "or" that's currently in there, or upon protest, and 7 days designation by the governor. That's going to make hell at my office.
Sure. Well, and likewise, in saying as such, Section D as well says gives you, auditor within 6 months. So it being critical in the beginning and then waiting 6 months for something to pan out doesn't coincide with
that's
the
why
other.
I offered that
Sure.
we could get the rules out within 30.
30 days? Okay.
Oh, well, initially I said, in my testimony, I said 90, only to comply with the Administrative Adjudication Act, which requires the notice.
Sure.
But if you pass a provision in here that says that I have shorter time period, I just give notice to the bar, and they get to respond to it, and we have proper notice, and everybody responds to it, then we can do it in a shorter period of time. But right now, complying with the Administrative Adjudication, I need at least 90 to comply with it.
I think we can all agree that the shorter things pan out, the better it is, because not only we heard from Attorney Camacho is here as well, that the court has its own delay tactics as well. So the sooner things can move forward, the better it is for everyone involved. Thank you very much, Madam Chair.
Thank you, Senator Lujan. Senator Barnett?
Thank you, Madam Chair, and good morning. Thank you for coming out to testify. I just wanted to ask Dr. Wampat about the custodial contract. How much is that? So if we're talking about procurements under $5 million, so just to give me a ballpark, like what do you think would be a good bottom for that? I mean, because obviously it's less than $5 million, right? But it is critical.
Yes, it definitely is. So it's under, it's about $2 million.
$2 million. And what other types of contracts would you deem critical to the Department of Education?
Well, we have three. One is the custodial. The second is our ground maintenance. And then the third is the infestation contract, to go into the schools and fumigate the schools. So those are the three.
And if there were, like Attorney Brown had said, objective, subjective criteria, I mean, you're confident that you can make the case that these are critical contracts, right?
Yes, absolutely. And I think because we have a middle person, so to speak, when we're talking about federal grants, not only do we have the third-party fiduciary agent, but we also work very closely with the U.S. Department of Education. So, and we confer with them during the whole process. And even before we start to move monies for whatever the contract, we always need to give them notice and reason and justification why we are using certain monies for certain projects, what have you.
I mean, kind of just to expand on what Attorney Brown said, I mean, I'm of the opinion that at this point, almost all of the contracts for GDOE would be deemed critical, right? So beyond those three, the custodial, ground maintenance, infestation contracts, are there other types of contracts that you think would fall under this that are under $5 million? Or is it just those?
Just those three.
Okay, thank you. And Attorney Brown, yes?
Comment on that. Infestation, so that the buildings are falling apart and that sort of thing, that's infrastructure, critical infrastructure. So it would meet, in my mind, the definition for that. Now, the other gets a little bit murky.
So when you talk about establishing criteria that's objective, can you maybe explain and expand on that a little more?
Well, in the case of that was raised about you have to do the inspections for bugs and vermin and that sort of thing. But what does that do? It makes that building uninhabitable. And so I think if you're dealing with something that keeps that building alive for use by students instead of just closing off parts of it because you got all this stuff going on. That to me is critical infrastructure. But apart from that, because you can define it, you can relate it to one of the elements that's in here, infrastructure. Apart from that, you just have to be a lot more knowledgeable about what you do every day, because I don't know what goes on in the government, to see whether it falls within the spirit of this bill.
What about something like custodial services? We're talking about, keeping bathrooms clean. I mean, are you arguing that that isn't critical?
I don't think that's critical. I mean, it's not in this case. Nobody's declaring the schools unsafe because of that. So if the school is not unsafe, then I don't consider that a structural problem.
Thank you.
Thank you. I mentioned the three because that's what we currently have. But we do have, and I agree with Attorney Brown, because we do have right now about $79 million worth of CIP projects. And some of those, yes, would be under, $5 million, but then there'll be others that will be greater than that. When we say that we want to do this for the health and safety of our children, because as you know, if public health gives us a D rating, then there's a bill before that you wrote that 14 of you agreed on that you want to immediately close, the schools. So yes, it is, I consider those to be critical.
Right. I agree. But again, if you have an idea or suggestion on a floor for, if we're talking about over $5 million, what in your opinion would be a good low end?
Well, there's several. There's the roofing, of course, air conditioning, renovations of all our restrooms, windows and doors to be changed over. Those are all part of the project. Yes.
What about timelines? You made a suggestion that we establish timelines.
Yes, we have. In working with GPA and the engineers, our timeline we're looking at is May to be able to get this work procurement out. We have the scope already, scope of work ready to go. And
Doc, you suggested that we include timelines in the bill.
Oh, for the timelines I'm talking about is when it goes to the AG's office. Right. We don't want it to be, I don't know whether you've heard this, but a memo went out to all the departments and agencies, inclusive of autonomous agencies, that the Attorney General is taking away the designation of Assistant Attorney Generals in the different departments and agencies in the hopes to bring them all back to the AG's office. Right. So that procurement process for us will bottleneck there unless we put some timelines that, to get these out to us. We can move quickly. We just don't want to be placed in a position that we are waiting for the review and for them to get back to us.
And so I know also part of the delay is that for GDOE contracts under 500,000, I believe, go to the AG for approval, right? Yes. I was, and I don't want to go off topic here, Madam Chair, but we were trying to find out where's the genesis of that is that, was it a memo from a former AG or is it in law somewhere? Because I remember we had brought it up at the roundtable for George Washington, and so when we talk about timelines and logjams.
Attorney Camacho.
It's a law that appears in Article 2 at the very end. And once again, the way that law, I think, had been interpreted by AGs past is that it somehow applies to GDOE, GMH, UOG, GCC, but these agencies are all exempt from Article 2 to the extent that it creates a centralized procurement regime. So it is kind of a matter of interpretation, but that's how the prior AGs had practiced, and I'm just going to enunciate a little bit and amplify the great concern that the agencies have with the withdrawal of the designation of Special Assistant Attorney General. We had that easily in the past, and these agencies have higher competent counsel, and essentially the checklist is easy. I would submit that any reasonable attorney could go through the checklist and make sure that it's done. It doesn't have to be by someone physically employed by the AG's office, and that will cause a bottleneck, a rather significant one. Thank you.
Thank you. You're good? Thank you. Thank you, Madam Chair.
All right, thank you, Senator Barnett. Senator Fisher?
Thank you, Madam Chair. I'm glad to hear that discussion about the involvement of the Attorney General in the process. That is found at 5 GCA 5150, and unless I'm mistaken, Mr. Public Auditor, I think you authored that bill, didn't you? Okay, good, because I have a question about that. The act that we were talking about says that the Attorney General shall act as legal advisor. Now, I've been an attorney for years, and I've advised clients, and they ignore me all the time. So I'm wondering if you could maybe expand a little bit on what you understood that phrase, shall act as legal advisor, means.
We passed that back in the 2011, 2010 period when there were lots of appeals that were going up from Department of Education. They were having problems with getting their procurement done because of issues. And we put $500,000 so that the Attorney General, someone from the Attorney General, or in the other agencies, a SAG, a Special Attorney General, is involved in the procurement process. They've developed a checklist, as Mr. Camacho made reference to, and all the SAGs that are out in the agencies have to comply with it and sign off on it and said they complied with this, they complied with this, they got all of these things done in the order that the Attorney General at that time determined that in order to be able to approve a contract.
Yes, sir. Is it your understanding, though, that an agency is free to ignore the advice of the Attorney General under this law, because it says shall advise? And I can tell you quite frankly, you know, I did a lot of work for agencies, and we were always looking for ways around, you know. It's just the nature of the beast.
I'm not going to, on the record, say something like that.
I'm sorry?
You're not going to get me to say anything
Oh,
on the record.
no, I
that
wouldn't want...
Anybody can and should ignore the Attorney General.
Okay, all right, so I guess we're not going to resolve that issue, but it does say advise. It doesn't...
Yeah, but they're involved, and I assure you that sometimes it can get rather cumbersome. Sometimes my staff has problems trying to move it through, but the thing is that, you know, either repeal the law or enforce it. I have no pride of authorship, and so if it's repealed, I'm not going to cry.
Okay.
But I just want to make sure that the people that are involved understand what the procurement process was. And, you know, at that time, 12 years ago, they were the only ones that knew procurement besides Mr. Brown.
Okay.
And so having them involved in it was imperative, because the agencies weren't getting people that were trained. And so it was imperative to include them in the process and have them go through the checklist.
Right.
But now whatever you guys decide.
Yeah, I don't mean to suggest that anybody is free to ignore the law, but I guess this is an issue of what it means to advise, and we're not going to resolve that here. And I'm not going to be able to inveigle you into saying it's okay to ignore the AG. No, not going there. All right, thank you.
If I could address that point too.
Please, yeah.
In practice, that means that we have the services of the Attorney General or the Assistant Attorney General every step of the way. And generally, they prefer, maybe insist, to be involved every step of the way. And you know, that's certainly helpful in making sure that we avoid any pitfalls along the way.
Right.
It may actually cause some delays because everybody has different schedules, but we generally have been able to work through that and have found it to be an advantage. And you know, we certainly don't want to, like the public auditor says, we're not going to ignore advice that's freely given.
Right, and I appreciate that, and I don't know that I disagree with anything either of you gentlemen are saying, but I mean, the verb is to advise. You're not, I don't read that to so broadly that the AG may halt a procurement based on their advice. But, I mean, those are things, I think those are battles for agencies to have. I want to speak a little bit about the automatic stay. I'll put my cards on the table. I'm a big fan of the automatic stay. I like it because I like the procurement. I get the whole idea. We want it to go quickly, et cetera. But I like the fact that the procurement process grinds arguments and litigants very finely. And I think that works out. You know, the agencies hate it, but the taxpayers love it. You know, we're saving money. So I like the automatic stay, and I wanted to address a question to Attorney Camacho. It's a hypothetical. Assume there's a protest, and there is no stay as a result of a law that we pass. And the protest appeal, there is no stay, and the awardee begins performance. There is a protest, but no stay. And the protest appeal is sustained. And as a result of that, the awardee is ousted. But again, they have begun to perform. Do you believe that the awardee, the original awardee, who may or may not have violated a procurement process, do you believe they are entitled to damages? And if so, how would you estimate the amount of damages they may or may not be entitled to?
Look no further than Article 9 of Guam procurement law. It talks about the remedies in the event a protest is sustained.
Okay.
And it all depends, the answer to your question really depends on whether or not the awardee was guilty of any bad faith. In the absence of bad faith, the procuring agency could actually ratify the contract,
yeah.
or they could nullify or void the contract, but then the awardee would be entitled to all the costs and his profit for the period up to where the contract was voided.
Okay. And anticipated profits?
The anticipated profits, the only time I think you see the anticipated profits is the provision of Guam procurement law and regulations that state the government will terminate, or gives the power for the government to terminate for convenience. And when the government terminates for convenience, that's where the awardee of the contract would be entitled to anticipated profit. Okay, but you're not going to find that if the award is voided because of a violation of procurement law.
Okay. Does that strike you as just, equitable? The agency has invited the initial awardee to begin performance, build a wall or a roof, or whatever, start construction of a road, and then they are ousted from the contract through presumably no fault of their own. It may have been a technical error. Maybe they didn't certify the procurement record, and the OPA dumps the contract. Yet again, the awardee was invited to perform and did perform. Don't you think they should be entitled to damages like in, quantum meruit or something?
No, I think that I agree with the existing setup. And this is coming from literally 25 years of dealing with issues like that. And essentially, I agree with the existing setup where they would be entitled to their profit and also the covering the costs or expenses up to that point where the contract is terminated.
Yeah,
Normally,
you just said profit.
No, profit. Okay, so whatever the contract price was up to the point it was terminated. That's no different than essentially in a regular civil case, if I'm going to argue that one of my damages, special damage would be anticipated profit, that would be a higher bar, a higher type of damage to reach, even in a regular civil case. Okay.
Let me direct, since Attorney Brown has been in the business of procurement forever, do you agree, we've been having this discussion on potential damages. Do you agree with Attorney Camacho's observations?
Let me read you the law that he was trying to refer you to, and he obviously didn't have it at his fingertips. This is Section 5452, remedies after an award. This applies when it's determined administratively or upon an administrative or judicial review that a solicitation or award of a contract is in violation of the law. So it's been violated through the procurement process. If after an award it is determined that a solicitation is in violation of a law, then if that person awarded the contract has not acted fraudulently or in bad faith, they can ratify and affirm the contract and give it to him.
Okay.
That's one thing. Or the contract may be terminated and the person awarded the contract shall be compensated
Okay.
for the actual expenses reasonably incurred plus a reasonable profit.
Okay, so they are entitled
Yeah.
to damages based on profit,
Yes.
or anticipated profit. So it sounds like they're getting.
Well, it's a reasonable profit. They,
Well, okay, they're getting actual and anticipatory.
Yeah.
Well, that's probably incorrect, but they are getting some compensation for the profit.
Yes.
Okay. All right, thank you for that. And I have to agree with the public auditor, although I sinned many times in this. In theory, the procurement record should always be ready to be divulged because it is a dynamic process. So, 2 days is generous, actually. I suppose, I don't know how long it takes to copy the document, but I totally agree with the public auditor. The procurement record should always be ready and always be ready for turning over, including the certification that the procurement record is complete. To me, that's a critical step, and frankly, sometimes agencies backfill on that one, and I mean, I don't think that's surprising anybody, but unfortunately it happens. And I do understand the public auditor's reluctance, and I agree with that as well, that bringing the governor under Section B is both confusing and potentially destabilizing, I suppose. I wanted to ask about the nature of a critical contract. Proposed 5428A sub 1 says the solicitation is one which is integral to the timing of the planning, development, construction, financing, or completion of major public infrastructures. And Chris is probably going to throw an elbow at me, but I don't think that under this definition of critical contract, that would include such things as mowing lawns and all that, although I completely appreciate the fact that this guy's moving heaven and earth to take care of the schools. But I think we could expand that definition of what a critical contract is, because I read this as essentially being a definition of the critical path and the completion of a contract. If something is on the critical path to the completion of a school, for example, then I think it would be arguably a factor in determining that it is critical. And I notice as well that this 1, 2, and 3 are conjunctive. You've got to have all 3 of these aspects in place. And God bless the agencies. God bless them for doing their work. But I don't want them making the determination of what is critical and what is not, because there's a natural inclination for any agency, I think, to move towards establishing something as a critical contract, because it smooths the process a little bit. So I don't know that I have a suggestion for that. I think the only way, you need expertise, and it would be nice, I guess GSA maybe possesses that expertise, but I don't know that everybody agrees with that. But all right. I don't know, the only way to fix that, I think, is to get a third-party expert involved to say that this is, in fact, a critical contract. Let's see. And then I guess the last comment I would have to make is I'm hesitant when we legislate, or when we legislate and the goal is speed, because one of my favorite sayings is you act in haste, you repent at leisure. So, you know, let's go over everything, to me, let's go over everything with that fine-tooth comb. Madam Chair, thank you very much.
Thank you, Attorney Fisher. Attorney, both of you raised your hand earlier.
I'm sorry, Madam Speaker. With reference to the procurement record, I think we also need to change how it's submitted. The requirement now is to submit a written record of all of it. For some of the procurements, the procurement record fills up a box, and so a day or two just to print that out without breaking all the printers at our particular agency is sometimes a problem. If we can submit it electronically, all we do is scan it, put a Bates numbering system on it and submit it. Unfortunately, the rules at the OPA now do not allow for that. So if we could modify those rules to submit electronically, we could certainly submit it in a timely fashion. I think as the OPA is aware, we've had several very expansive procurement records, and just the copying alone is difficult. Scanning and submitting electronically, we can do within a day or two. Sometimes the copying takes longer.
All right, thank you. Public Auditor?
Madam Chair, I support that too, because we've been we were faced with having to scan it and then print it out again. And
Yes.
that obviously is a waste of effort.
Public Auditor?
We can amend that very quickly. We've already given notice to everybody that we accept electronic. In fact, we're trying to go completely completely paperless, because my office is a fire trap. I have boxes to the ceiling from procurement records that were in paper, and I was reminded by my predecessor that by law I have to maintain all that paper that I have. It literally has taken a whole office space just for paper. So I would gladly amend the rule to just have electronic.
Okay, thank you. One problem solved. Okay, I'd like to recognize Senator Taitigui.
Thank you, Madam Chair, and good morning to everyone here. Thank you for being here. I think this prompt, the reason of trying to spend the ARP funding as quickly as possible before it runs out, and this procurement has been, bottlenecking, that's the word that's been used quite a bit here today, with regards to using these funds and getting these bids out for critical areas. I was going to talk about the custodial issue. I did talk to you, acting superintendent, about that. Unfortunately, that might have to be addressed sooner. One of the other words that I appreciated was the word shenanigans, because I truly believe this bill was put in, the current law right now was put in place to protect that, and any kind of shenanigans going on that Mr. Brown had used. It's my favorite word here in the legislature. But I do believe the importance. I think we came into the situation with the ARA funding that came in, where I called the public auditor and asked him what happened during that time and how we can, move forward in spending this money without losing it, millions of dollars, tens of millions of dollars. However, because of the speed and because we need to get this done right away, I think there's certain things that I'd like to amend, and just wanted to know, Public Auditor Cruz, in your testimony, you said that for a special expedited process within 90 days, this is regarding promulgating rules and regulations. Could you do this in 60 days instead of 90?
I did say yes. For promulgating the rules, yes. The only reason why in my testimony I said 90 is to comply with the current requirement of the Administrative Adjudication Act. If there is a waiver of the Administrative Adjudication Act that I can promulgate some special rules in a shorter period, I can do it within a shorter period.
Would it be I'm sorry.
But I'm not going to do it unless you give me the authority
the permission
to do it.
to do
Otherwise,
that.
I have to comply with the Administrative Adjudication Act, which requires 90 days to go through the process.
So we would have to, Madam Chair, look at some type of mechanism. I mean, we're talking about time here, and that's why we're here. It's critical. Looking at allowing that to be bypassed or notwithstanding or whatever mechanism there is. Mr. Burns, do you see an issue with that? Like bypassing some of the adjudication, the AAA process to get this done?
Senator, if you authorize it, then we will comply.
We'll get it done? Okay, so then it could be sooner than 60 days, even, maybe even 30. Okay, sounds good. Okay, that's something I'd like to look into. There is one other concern I had. Most of the questions were asked that I had here. Earlier, OPA Cruz, you mentioned something about on the stand you agreed to dissolving the stay, but you mentioned it would be up to us. Now, what do you exactly mean by the legislature, it's up to us dissolving the stay? Is that something for us to put in the legislation? Or what exactly do you mean by agree to dissolving the stay, but it would be up to us?
I think that the recommendation was made by Mr. Camacho that the stay could be dissolved after the OPA issues a decision rather than waiting until it goes to court. Because, as he put it, sometimes it takes another year and a half before the court addresses it. Sometimes it's even 2. And so if you give us the authority to dissolve it, then fine. I just don't want the authority to impose it.
I see. The other question I had is this is from the GPA representative. In your testimony, you had concerning the proposed new 528B, GPA respectfully requests the following amendment in section B. Put up the current law right now and seeing where you're changing this. So you go to section B of the law. Maybe critical, okay. What new language are you incorporating here? And can you kind of give more of an explanation why you would add what you wanted to add?
Well, Senator, the way currently the procurement is done for GPA, the port and waterworks is such that in the case of waterworks and Guam Power Authority, any procurement over $1 million requires the approval of the Consolidated Commission on Utilities, and any procurement in excess of $1.5 million for power and $1 million for water requires the approval of the Public Utilities Commission. Our perspective is that for these procurement matters, we do not have any dealings with either the governor's office or the AG's office. Now, if it is correct, obviously, that the AG's office has removed all the special assistant attorney general designations, that may be a separate issue. But prior to that, all procurement is done by counsel that work for either the port or GPA or GWA. And so that designation as it stands now in the proposed law is ratified by the governor and or the AG's office. We would propose that would be the governing body, in our case would be the CCU that would approve that designation. I think that it is not that substantive change in that the definition in the proposed law, in our case, would be pretty straightforward. It's a critical infrastructure project, and it's over $5 million. I don't think, unlike DOE, I don't think we would be asking to modify that in any way to either include for a lower amount or for other services that, as Senator Fisher has indicated, that there might be some questions as to whether it's truly critical or not. So I think we'd have no problem sticking with the definition in the proposed law for their critical designation. And we would just suggest that, the CCU would have the authority to ratify that designation, given that, to be honest, the only time we deal with the governor or the AG's office is not for procurement, it's for bonds. I mean, we're required to come to the legislature for approval, and then not only that, but the PUC, and then the governor and the AG's office would have to sign off on that. So that's really the only time we would come to those particular agencies.
Thank you so much for that. Attorney Camacho, you want to comment on that section? You've always been my go-to person, when I have questions about procurement, when I give you a call. Fortunately, I didn't have an opportunity to call you before this, but, on GPA's issue or their concern, do you have any comments on that?
Yes. Having also been the staff attorney for the GPA and
Right.
GWA and the CCU, of course, over almost 20 years ago now. But my experience there is absolutely on point with what Mr. Botha has said. These are agencies that are regulated by so it's really the Public Utilities Commission that reviews the contracts. Adding an extra step would be unnecessary and also would be a bottleneck, as well as GWA and GPA have historically hired very competent counsel to basically review these contracts. Like I said, if it's just the checklist, any reasonable attorney can go through the checklist, go through the record just to ensure compliance. The PUC looks at the essentially the contracts from GWA, GPA, and also the Port Authority of Guam to kind of ensure a general compliance with the law, but also to see what the effects the contract will have on the rates charged by these agencies.
Right.
So,
yeah, I think that's the most important thing too.
yeah. So I agree that if there's a concern about the purchasing agency making the determination that something's a critical procurement contract, each of those agencies has a board. In this case, it's another elected board. You have the CCU that's elected. They could make that determination if you didn't want the general managers of GWA or GPA to make them. Likewise, the Port Authority of Guam also has a board that could easily make that designation as well if there was a concern about the general manager of the port making it unilaterally. Thank you.
Okay, thank you, Ms. Attorney Camacho, for that. Now, my last question would be to Acting Superintendent Wampad. With regards to ARP funding, this, why we're here. I mean, this is all the infrastructure at DOE that needs to be done right away, and it's been delaying it for so long. The funding that you're going to be using to address the critical needs of DOE on the infrastructure, will they all be paid by ARP funding, or will some of it come from general fund, what was appropriated to DOE?
Currently, we are using ARP funding. Because we had to put in a request at USAID to be able to address smaller type projects. But what we are trying to do now is that to see as much as possible if some of those can be transferred over to or redirected to ESF, the Education Stabilization Fund, so that more monies will be available to use strictly for facilities. But that's the plan.
So, but it's still ARP funding, all ARP
Yes.
funding? You have no money that's been appropriated to you to cover that, or a bid that goes out that is not ARP funding?
No, right now it's all, we're using ARP monies.
Public Auditor, you're thinking of something that might...
No, I just wanted to apologize for messing things up this morning by not wanting procuring agencies to do it. I withdraw that concern because I'm reminded that the autonomous agencies are going to the PUC to approve contracts over $1 million.
Right.
But someone else has to approve. And for the line agencies, having the governor do it by recommendation of somebody, whoever she uses, but someone to oversee the line agencies but just not the agent, but in the autonomous agencies, they do have someone that's overseeing them that's above the GM.
Okay.
And so I'll withdraw my
Okay.
consent.
Okay, so noted. Thank you. That's all the questions I have. Thank you, Madam Chair.
Thank you, Senator Tadegui. Senator Brown?
Thank you very much, Madam Chair. Certainly welcome to everyone on the panel this morning for providing your input. This whole issue of government procurement has always been a wonderment to me because I see ourselves, because we create our own laws that constrict our ability to procure the things we need. And unfortunately, as Attorney Brown mentioned, because of the shenanigans in the government, we have all these additional requirements that in some cases almost make it difficult to procure the most basic things that you need to operate. That combined with whether or not those that are tasked in a government agency are fully well versed and have gone through the modules and training to make sure they're doing proper procurement. And for those that have to go through GSA, because I understand your General Procurement Officer is still not here, who is doing the procurement and signing off for GSA these days?
They have a staff, and they're actually
I
processing.
hope they're qualified to be signing off on those procurements.
They're
but-
actually processing like 200 POs.
Yes,
every
I wonder
week.
why. I hope our chair calls an oversight on GSA soon so some of those issues can come to light. But I think anything that we can do to help facilitate proper procurement in government, but yet not to the point that we are constricting our ability to get the goods and services that we need. And it's one of the biggest criticisms of government, our inability to respond in a timely fashion to things we need to do, hence the issues with DOE. It continues. It continues perpetually every single year, and many of us have been at this for quite a while, and we're still in the same situation. So certainly I'm supportive of the, as in co-sponsoring this particular bill. For over, 5 million, but I wonder, is this something we need to look at overall with government procurement? Because we are the ones who limit our ability to procure. We also have individuals in the private sector that if they don't get the contract, guaranteed, and those of us that have run government agencies are familiar with them almost by name. If they don't get the contract, guaranteed, they will protest. Because what's the sweat off their nose? It makes their competition, sweat it out, but it doesn't cost them anything. And I think that's what we need to look at, because that to me is also unfair. And we ourselves create the circumstance that make it difficult for procedures to move forward, because we feel we need to accommodate everyone in this idea that we are going to get the best deal going through this certain procedure to make sure that we're going to get what we need. But when I see us procuring, cardboard boxes because it has the government of Guam written on it, and they cost over $20 to file documents. When I was at DPW, we had to pay over, almost $700. You know that little stop sign that the bus driver manually pulls out to hopefully stop the traffic that keeps driving by? $700? Really? Those are the things in procurement that really have me wondering, because I'm like, we're not saving our people money. We're costing them money, and time costs money, especially when we need to, be it in construction or other things that we need to procure to meet obligations that we need to meet on behalf of our people. So I think this is an important step to do it. I think there's things, certainly, Madam Chair, we need to look a little further in how we can facilitate for DOE. And I'm not going to give them a free pass card either, because I have, I'm concerned about some of the issues at DOE that have been long-standing, and no matter who's there, hopefully with our current acting director there, hopefully we can see a little more progress. But I think we need to, in some areas, really look at how can we effectively address the procurement issue, because this has been long-standing. And the excuses are it's the agency that's either not getting their act together, or they'll all point at GSA and say, well, GSA isn't processing, or so-and-so isn't processing. And then we're where we're at. And at the end, it ends up costing us time in accomplishing what we need. And in some cases, it ends up being more expensive. Be it the procurement of Simon Sanchez that we've heard over. Gosh, we would have graduated by now if we started in the first grade. We'd be graduated already, and Simon Sanchez still wouldn't have been constructed because these things have gone on for so long. And that's what ends up driving the direction. It's not the policy that drives the direction in terms of wanting to accomplish and get the things we need. And we have been very limited in our ability to do that. And I think anywhere that we can facilitate that, and yet at the same time ensure that things are being done properly so we don't have the shenanigans, because we do have interest out there that will take advantage of every opportunity they get. And I hope that we also look at those vendors that, again, are constantly protesting, and there's no charge to them. They get to walk away and just protest, and everything sits. That's a creation of our own making. Why do we do that? Why do we constrict our ability to procure the things we need in government? It's mind-boggling that we allow this process to continue, and then they end up driving the agenda. And so I think we need to look further into that, because it should cost you. If you're going to stop us from moving forward, unless there's really some egregious action that has occurred, I think we need to do everything we can to facilitate procurement, because we have cost our people more money by the inefficiencies in the system that keep us from doing what we need to do. So I certainly appreciate the input of all of you. I do request, Madam Chair, because we don't have the Attorney General here, and I think he's a critical component to that, that before this bill moves further, either a roundtable or further discussion or a markup meeting, and have him come and provide input, or his representatives come and provide input, so that we can also get his direction with regards to the procurement and the 500,000 and so forth, so that we can get his input with regards to that. Because I do agree. I'm well aware that as anyone run any major operation in this government, there is always outside interests that want to facilitate their agenda. I just want to make sure it's not being done at public expense, and that has happened time and time again. You might look at this now as $5 million, but I think in many other areas of our procurement, this would be what we should expect for all procurement. Because I'm sure agencies are not procuring things just for the heck of it. I'm sure in almost all cases, it's something that they need, be it a good or a service that they need to facilitate their agenda. So I don't have any questions. I appreciate all of you providing your input, but I think we need to maybe roll up our sleeves and look at how we can more effectively address that. And if someone's just flagrantly making it difficult in the system because they don't like their competitor, and if they don't get it, well, nobody's going to get it. I think we should put some consequence to that, because that should not be what drives our agenda with regards to public policy and ensuring that we get the things we need to do for our people. With that, Madam Chair, thank you for the opportunity to comment.
Thank you, Senator Brown. So I just want to thank everybody's input here today on Bill 36-37. The committee will continue to receive written testimony until 4 p.m. February 24th. Please address testimony to Senator Sabina Flores Perez, Chairperson of the Committee on Environment, Revenue and Taxation, Labor Procurement, Statistics, Research, and Planning. It can be dropped off the mailboxes here or emailed at office@senatorperez.org. If there are no further testimonies on Bill 36-37, this bill has been duly heard. And now to our next item on the agenda. Bill 45-37, COR, sponsored by myself, Sabina Flores Perez, is an act to amend Section 5230 of Chapter 5, Title 5, Guam Code, annotated, relative to clarifying the process for the determination of responsibility of bidders and offerers in procurement. I'd like to acknowledge my colleagues that are here today, Senator Jesse Lujan, Senator Chris Barnett, Senator Tom Fisher, Senator Tello Taitikwi, and Senator Joanne Brown. So just a brief introduction. Bill 45-37 aims to clarify the process for the determination of responsibility of bidders and offerers in procurement. Whereas the bill we previously heard intends to expedite protest process for procurement, this bill aims to avoid potential protest by including in the determination of responsibility special standards of responsibility for contracts that require specialized capabilities. The determination of responsibility of a prospective contractor is necessary to meet the needs of government for goods, services, and construction in a timely fashion, and responsibly involves the question of determining the capability, integrity of a contractor in performing as it is promised. In communication with some of their constituents, there was a concern that there was a lack of clarification for when specialty licenses are necessary to meet one of the requirements for demonstrating responsibility. And this lack has resulted in protests that are costly and that delay the procurement of much needed supplies, services, and construction that serve our island community. Bill 45-37 intends to update current statutes by clarifying those standards. This bill specifically requires written determinations of non-responsibility of a bidder or offerer shall be served prior to awarding of a contract, although a finding of non-responsibility in one instance does not require a finding of non-responsibility in a dissimilar solicitation. The second thing it does is when necessary, the procurement authority shall consult with the Guam Contractors Licensing Board to determine if specific licenses, certification, or specialized facilities referred to as special standards of responsibility are needed for adequate contract performance. And the third thing it does, Bill 4537 does, it strengthens the right of non-disclosure. It specifies that trade secrets or confidential proprietary information is not public information and should not be disclosed outside GSA, DPW, or the purchasing agency without prior written consent. There was a fiscal note waiver that was received February 17th. And so I would like to proceed with testimony. We have Public Auditor B.J. Cruz here to provide oral testimony. You're recognized.
Thank you. The Office of Public Accountability, Madam Chair and committee members, the Office of Public Accountability submits this testimony in support of Bill number 45-37 introduced by Senator Sabina Flores and other committee members. Bill 45's intent to update current statutes by clarifying standard and processes to making a determination of responsibility, providing for specialty requirements with the assistance with experts. It is necessary for successful completion of a contract, and that applies to all bidders and offerers. Our office supports the idea of having something in place that is stricter when it comes to determining responsibility, whether it be more affidavits included in the certification, in certifications put in place before the awarding of a contract. As an example, as it comes to construction projects, the purchasing agency should have that assurance that the construction company has the personnel, financial responsibility, and licenses in place when they place their bid. I know that in this bill you want something more specialized, and we had several appeals because of a specialized contract. A specialized license being needed. And I see Mr. Brown and Mr. Camacho here. I think they will be able to elaborate more on the need for having this up front. I know that currently under the way we learned Module 1, licenses can be had, are not necessary in the initial bid, but can be had by the time the contract is signed. That can sometimes be problematic because you don't know whether or not that person's going to be able to get the contract. I've been arguing for a long time that the license should be there at the beginning. I use the example in my office. If I'm going to hire a hearing officer, and I say that the person has to be licensed to practice on Guam, should that person have the license at the time they make the bid to the office or submit their RFP to the office? Or should it be at the time that I give them, they award the contract? What if they're not able to pass the exam by that time? It just messes everything up. And so I've been trying to figure out a way to have it earlier and demand that all the licenses be in place at the time that the bid is submitted, rather than wait. I know there's going to be the argument that, well, they don't want to have to go through the expense of applying for the license and not getting the award, but it just seems to me that the license is, if it's a license that requires some kind of test, then it should be had before the bid is submitted, or at the time the bid is submitted. If it's pro forma, like getting a business license, all you have to do is go up to Rev and Tax. That I have no problem with that, because there really is no license, no problem as long as you don't have a criminal record or you don't have some outstanding other problems that would prohibit you from getting a license. But if it requires a test or special qualifications, I think it should be before they submit their bid. Anyway, I think I diverged. But yeah, we support the idea of responsibility being determined earlier. And this is not the only problem that you're going to be having in the future. Right now, there's the issue of whether or not contractors have the requisite personnel to be able to fulfill the contract. There should be something to make sure that they are able to. And, you know, maybe something from the Department of Labor that says they have sufficient personnel in this company, or whether they apply and they're on the line to get some H-2 laborers and it's not going to be approved. What happens to the contract then after you've awarded to them? So that's why I think it has to be ahead of time that these things have to be made. I'm dealing with this one case where I don't know how the agency found the contractor to be responsible when they hadn't required certain licenses to have been provided. And then before the contract was being signed, the agency all of a sudden said, maybe we need a national license to show that you are qualified. Maybe we need a couple of things. And I'm going, how did you find this person responsible to get this contract when they didn't have national licenses, or that should have been part of the process in the evaluation committee. And if I had my way, I would recommend lots of affidavits up front of certifying that they are licensed, that they have all of these things in place, like we have the license, the affidavits currently on non-gratuity and a couple of other things, shareholders. But there should be more so that the agency can properly evaluate whether or not they have qualified people. But we support this one, at least as a start.
Okay, Suzu's Masi, Public Auditor Cruz. So I would like to now recognize, so we had Director Byrne. I believe we would reach out to him later. Then I would like to now recognize Attorney Brown for his testimony.
Thank you, Madam Chair. And Senators, getting to our public auditor's understanding of having a license at the time you submit the bid is built into our law that you don't. And by the way, this bill as it's written is basically a regurgitation of regulations and laws that we already have. So to a big extent, it's just redundant. But a determination of responsibility or non-responsibility shall be governed by this section. This is 3116 of the GAR. And it's in the regulations because the law, 5230 GCA, says the determination of non-responsibility, a written determination of non-responsibility shall be made in accordance with regulations promulgated. So we have the regulations, we have the law demanding that happen. Turned it over to the people who drafted the regulations. And factors to be considered in determining whether the standard of responsibility has been met include whether a prospector has available the appropriate financial, material, equipment, facility, and personnel and resources and expertise, or the ability to obtain them. That's what you have to have. You have to be able to show that you have that ability to obtain all these resources that go, or these factors, any of these factors, goes into a determination of the standard of responsibility. It includes a satisfactory record of performance, satisfactory record of integrity, qualified legally to contract with the territory. This is basically understood to be a business license, a regular business license, not a contractor's license in particular. But you also would have to have that. Because if you don't have the personnel resources and the expertise, you're not responsible. And the other thing is, and it's in the law that says that the prospective contractor may demonstrate the availability of necessary financing, equipment, facilities, expertise, and personnel by submitting upon request. So the agency has to ask for this. Upon request, evidence that the contractor possesses the items, acceptable plans to subcontract for necessary items. When you need a contractor with a particular license already, yeah, I'm gonna, so you have to prove that you've got that set up, but that covers, you're covered by that way. You know, getting a lot of licenses, also in some instances you'd be paying bonds to just do the work, and you don't want to get a contract that is going to require you to get a license that, and once you have that, you're going to be paying a bond, and then get thrown out because you found something else that makes them non-responsible. It's for the contractors. It's really kind of existential that they can cover their. They know they're going to be able to cover their costs at the end of the day, this is the way we have structured. And this is pretty consistent with the way it's in the FAR. So, yeah. So if a bidder or offeror otherwise would have been awarded a contract is found non-responsible, written determination of non-responsibility, setting forth the basis of the finding shall be prepared, and a copy of the determination shall be sent promptly to the non-responsible bidder or offeror, saying you're non-responsible, you're out of here. That takes them off the hook of getting a license or licensee under a subcontract before it's ready for prime time. So you ask for it. If you want that stuff, you can say, provide it in your solicitation. Say, provide this, but they don't have to, because one of the ways that they don't have to do it is by meeting the ability to provide that. Again, you ask for it. The unreasonable failure of a bidder or offeror to promptly supply information in connection with an inquiry, you're asking them to provide it. That's the inquiry into their responsibility. If you don't provide that information, so that can be made, you're non-responsible. Just bingo. But I think that responsibility issues are sui generis. You know, they're going to depend on the contract that you have and all of that. And I think it would be handy to keep a unified list for the whole of government of contractors who have been determined to be non-responsible. They do that at the federal level. They've only just recently started in the last couple of years having a government-wide list of that sort of information that an agency can turn to. And that goes to having also something, if you recognize that this person has been challenging a lot of bids, if you have that information, I think that's, to me, that's an indicia of non-responsibility. I don't know that we need to do a real surgeon's approach to this bill because, as I said, it's almost all of it. A written determination, non-responsible shall be made, and served on a bidder prior to award. I just read that in here. You know, before award, that's when you determine non-responsibility. You determine responsive. Is this bid responsive? You determine that when the bids are open. Because you have to have a responsive bid at the time that the bids are open. That's what it says in the law and the regulations. In the responsibility, it says you determine that before award. And what is that determination? You know, the determination of responsibility is, there's no law or regulation that explains how that should look. It's the unique, one outstanding determination. The procurement law throughout requires determinations, and a determination has to be supported by facts and circumstances. But no determination is required here. You can make that determination at the end, but if it's not of someone who's going to get the award, the only person that is entitled to that notice of non-responsibility is the person that you have determined to be non-responsible. Nobody else is entitled to it at this point, unless we keep a record of it. So I like the idea of looking at these things and seeing if there's something that's been left out that we're already doing, and I couldn't find any. Frankly. Right of non-disclosure. Information furnished by a bidder or offeror pursuant to this section shall not be disclosed outside of GSA, Department of Public Works, the purchasing agency, without prior written consent of the bidder, but it can be disclosed to the Attorney General. That's in our law, 5230. So that's what we've been trying, that's what this bill reads like. I want to address this notion of a specific license, particularly in the contracting and licensing board. That I can see that can be a difficult one to do. But the agency is in no position to determine for itself, typically, and particularly in some of these arcane specialty licenses, what kind of a license is required. But the licensing board, the contractor's licensing board, does have that not only authority but duty, is to issue a license, determine a certification, what classification that it is, and then issue them if you find people that can meet the requirements for that license. So if there was going to be anything in here, I would say make a requirement, and this does speak a bit to that. It says, when necessary, the chief procurement officer or designated procurement authority for the purposes of this section shall consult with the Guam Contractors Licensing Board to determine if specific licenses or certification or specific facilities are needed for adequate contract performance. So it puts the onus on the agency to make that effort to determine, do we need a license for this? And if so, what kind? And you don't make that your determination yourself. You ask the experts, the contracting licensing board. That makes sense to me.
Does that conclude your testimony?
That's it.
Okay, thank you so much, Attorney Brown.
Thank you.
Attorney Camacho.
So of all the bills before the committee today, this is the only one I opposed. Okay, not entirely though. I do agree with the concept of being very concrete and specific. in a solicitation. However, this is a touchy subject, just so you know, and here's the issue. Let's say I'm an off-island contractor. I definitely could get any Guam license I required, either by hiring somebody here who's got the licenses, or essentially applying for them myself. But there's not much incentive for an off-island contractor to do so prior to getting an award for a contract. So, as written, what worries me is, as written, this might be a way to basically have an on-island contractor argue that some off-island contractor is somehow not responsible simply because they might not have one of these licenses. So, for starters, as attractive as it might make or be for, have the agency contact the Guam Contracting Licensing Board, sometimes these, in very, even what I think are simple construction projects, if you look at the licensees required by the Guam Contractors Licensing Board, sometimes there's several, sometimes there's dozens, and there's tens of them. So essentially, and it's really up to the Guam Licensing Board, just like it is for the Guam Bar Association, to govern contracting on Guam, to enforce those standards. The agency itself, to use legal parlance, to me it's like a slippery slope. This is just an avenue for an on-island company to say that off-island company, although we know they can do it, we're just going to argue that they're not responsible, and we're going to make it harder for them prior to getting the award. We're going to burden them. Show us that you have the ability to get the license. So that's my only worry here. Okay, and then the other issue is, or to defray that issue, or to alleviate it or mitigate it, I wouldn't mind language here saying, in subsection B on the page 2, or the first page of it, or is it page 2? Sorry, I don't have my glasses on. Yeah, it is page 2. Where it talks about the special standards of responsibility, state that a contractor who shows a ability to obtain any necessary licenses should not be shall not be deemed not responsible. Okay, so or something to that effect, which would allow off-island contractors essentially to bid on construction contracts here on Guam. So I believe that it is kind of a touchy subject because the public auditor is absolutely correct. Sometimes when the contractor places the bid from off-island, they do have the ability, but then something occurs here. I'm thinking of one case where in between the award and them getting the H-2 workers that they needed to do the job, they were cited with violating the H-2 laws, essentially, and there was a holdup there. So the public auditor is correct in that that might have an effect on responsibility, but at the same time, like I said, the balance here would be struck by allowing these off-island contractors who, because of their scale, might be able to offer these services at a lower rate. So that's kind of the balance that I just asked. If that's struck in the bill, that would be fine, but as written, I see this as an avenue to attack the responsibility of the off-island contractors who don't have local licenses. Thank you.
Thank you so much, Attorney Camacho. I'll withhold my question, but I just want to give the opportunity for Acting Superintendent Judy Wampat to provide testimony.
Thank you very much. GDOE supports the intent of this bill, as clarification of bidder responsibility will help strengthen the procurement procedures. The clarification will minimize protests on the basis of bidder responsibility and ensure that agencies are procuring qualified vendors. However, if I may take you to page 2, which is subsection B, lines 20 to 24, where these different individuals are referred as procurement authority for the purpose of this section shall consult with the Guam Contractors License Board. My concern, and there's been several cases that I've actually heard of, that when that some of these requests would actually sit and there's no response. And my fear again is that, you know, although the intent is great, is that sometimes it can slow down the entire process. And the same with the other bill is the possibility also of putting some timelines as well, so that then we'll be able to move forward. So, and that's my primary concern. Thank you.
Thank you so much, Superintendent. So Attorney Camacho, so I know you provided some amendment language for an amendment. If I were to adopt that change, do you think that would address the concerns that you have?
I do. Just some opportunity for someone to, or some language stating that a contractor that, or a bidder or offeror who otherwise has the ability to obtain the Guam license within the performance time needed should not be deemed unresponsible. That language, I think, would mitigate my concern at least. Okay. Because we are supposed to promote broad-based competition. Further, the construction industry here, although it's large now, typically has to go off-island to get various types of additional services that it might need. And it might take time for that off-island subcontractor or portion of the team to get licensed here. So that shouldn't, this shouldn't be used as a way to have somebody deemed non-responsible, you know, at the get-go. That's my only concern with this bill.
Yeah. Yeah, great. Thank you for pointing that out. It wasn't my intent to do that. It was to address a lot of these concerns where the protests were based on the lack of licensing. And so I just want to bring the question back to a public auditor. Would that proposed language assist with preventing protests regarding this particular topic? I know that's like
I'm thinking of a couple of the cases that we've had. I think the protest would still have been the appeal would still have been made to our office because the on-island contractor insists that the off-island contractor does not have that specialty license and should have been found as non-responsible. And all that would have been necessary would have been for the off-island contractor to have, like in another case, they have an existing contract with an on-island person who has that contract, and it's listed on their bid that so-and-so is going to be the person on island who's going to be our I again go back to my attorney thing, where when I'm looking for hearing officer, if someone says, I'm going to have I'm going to have my license by the time this contract starts, or in the alternative, I have a on-island attorney that is going to be able to fulfill the terms of this contract if I don't have my license in time. In the same way with the contractor, I may not have this specialty license, but contractor E is my electrical person on island and will be able to fulfill that part of the contract. And so I don't need that specialty license myself, but I have within my, contracted to us and available to me to fulfill that. And I think Mr. Brown is correct. The agency just needs to ask for that. And it would help. I mean, I can't believe the number of times that I see cases where, why didn't the agency ask for this up front? I mean, maybe not, to prove your responsibility, ask for it. I can understand, because in one case, the agency asked for it, and the winning bidder threatened suit for the request. Got an attorney to write and say, I don't know why you're doing this. You already said that we had the contract. You've signed off on it. It's just awaiting the governor's signature and the AG's signature, and now you're going to mess everything up by asking for this to delay things. And I'm looking, I'm going, these are very reasonable requests. How could you have even found them responsible when they didn't have, when this wasn't evaluated? I don't know what the evaluation committee did to have found them responsible. So it's, the evaluation committees need to demand that certain things be provided to them up front, so that they know if that person is responsible and not wait. And as Mr. Brown pointed out, you have that ability to be able to ask for it. And they just need to exercise it. Yeah, and exercise it.
Yes, I appreciate that. So it appears this problem is more of an administrative fix. So to address this problem, there has to be more emphasis on the procuring agency to go through that questions and seek that information. So I'm getting, yeah, I'm hearing the message very clearly.
Yeah, I mean,
Yeah.
you know, it seemed to me that I wish the IFBs were more like the RFPs, because in the request for proposal, you have to have, or at least in the ones that we handled in our office, it's very easy to determine responsibility, because when we ask for accounting firms, I mean, in the past, before there was only one locally, they would submit a bid package that had everybody that's going to be involved in this audit for this agency. They have a picture of them, they have their CV listed, they have everybody that's there, and so when you look at it, you say, accounting firm A has this personnel. I really like this one because he has a person that, you know, it has a person that has all of these degrees and all of these certifications. Accounting firm B does not. With IFBs, it's lowest bid. And you don't really know whether or not they have enough people, whether they, you know, you need to ask, do they have enough people? Do they have enough money to pull things through? And the other thing that I like about the RFPs is they list all the contractors that they've had, contracts that they've had for the last couple of years. And we make a determination to reach out to 3 or 4 of them, maybe 5, and ask for recommendation. And if the recommendation comes back low, then they score low in our evaluation. But in an invitation to bid, there isn't that initial clearance, and the lowest bidder wins. And unless we have a local registry of non-responsible or irresponsible contractors, she's not going to know that the cleaning crew that she's hiring was a dud at the airport and was hated by the port because there isn't that registry, and it's not in there, but they have the lowest bid, and they're going to get the contract and then mess up, leave the schools a mess. But that's going to take a whole process to get. And I don't know if I have my mentor here and my guru, whether or not that can be demanded of evaluation committees or in the IFBs, whether we can demand that, because I just don't know how the evaluation committees are doing those evaluations.
I appreciate that point. Attorney Brown?
Yeah, as I said before, you can ask. You should ask. You're not going to find out if you don't ask, because it's not meant to be part of the bid packet. And the other thing that's very interesting and catches people completely off guard is, as I said before, the only determination that's made about responsibility is whether or not you are non-responsible. You don't make a determination of responsibility. The duty concerning responsibility in the regs before awarding a contract. So this is when you figure that one out. Before awarding the contract, the procurement officer must be satisfied. That's it, that the prospective contractor is responsible. Just satisfied. But you have to go through a whole selection of factors and balance those factors to see if they are non-responsible. It's an anomaly in the way this is set up, but it really works well.
I believe in the federal procurement, they actually have a determination of responsibility. Here on Guam, we have determination of non-responsibility. Yeah, that's
I don't
one
know
of the.
for sure. I don't know that.
Yeah, that's another step, I think, in regards to, maybe addressing the issues. But I do like the point about maybe we should have more better records within the government as far as which companies out there are good performing companies. That's something that we can look at too as well.
They're just getting around to that at the Fed level, and they're moving into it very, very slowly, where they have records of all the non-performing contractors that they've dealt with. And as it is now, they're finding that if they've had if a contractor has had a bad showing on one contract, he just forms a new subsidiary or new name and does it again. And nobody knew that was going on. Well, of course it goes on. Of course everybody knew it goes on. And it's vital that we get those statistics.
All right, thank you. Yes, Acting Superintendent.
Thank you very much, Senator, seriously for this bill, because just actually hearing from the experts here to my left has just enlightened me now with all the different procurements that we will be doing that I didn't know about upon request. And this is something I think that I bring back to the department to actually put it on as part of our checklist, because I think it would really help us as well to know then who are actually licensed out there and who will be able to carry out the work. And I agree with my colleague here as well, although I know, and I don't necessarily like that, and with the IFBs, you get the lowest bidder because sometimes the work is just not performed to our satisfactory, or they give us materials that are of lesser quality. I like the evaluation process, and that's something I think we can actually discuss. And the reason why I say this as well, because we are actually in the process of writing up our transitional plan for procurement with US Ed in terms of transitioning the third-party fiduciary agent then out of the role that they play with us and our federal funds for us to eventually take over, and making sure that then that we have this one flow chart that would be for all federal grants that we have and also our local funds. So I think it's a great thing for us to do and get in place. Thank you.
Right, thank you so much for that point, and I'm really glad everybody's here to discuss this, very problem that has been plaguing, I think, a lot of the procurement. So, and we're coming to a resolution, hopefully. Okay, I'd like to recognize Senator Lujan.
Thank you, Madam Chair. I see both sides of this equation here. Of course, with Attorney Brown saying, of course, that's at the request to show upon request the ability or having the licensure. But I also see Attorney Camacho's that most especially the off-island contractors being able to provide more of the competition in contracting, but even being able to show the ability to obtain those particular licenses or particular license that will be sought or needed in order for them to participate. And that would just exacerbate the situation even more if my bill passes, because you have one website that you would have all these procurement RFPs and IFBs, and so you'll have more inquiries, and so you'll probably even have even more off-island contractors inquiring about the RFPs or IFBs. But as long as they're able to demonstrate their ability to obtain a license or licensure for those particular RFPs or IFBs that go out. But I also see the other side of the equation, that you get the lowest bidder, but you don't know the staffing, and we heard that in regards to the roundtable that we had with DOE in regards to their maintenance as well. That has not been working. So interesting. Again, I love competition. I'm all for that, and the more we can make it a lot better and easier for competition to happen, and then demonstrating the fact that they can be licensed, have the ability to acquire such license. I see the attorney's point of view of that. Thank you, Madam Chair.
Senator Lujan. Senator Barnett.
Thank you, Madam Chair. I'd like to yield to Senator Fisher.
Senator Fisher.
Thank you, Madam Chair, and thank you, Senator Barnett. This law, to Mr. Brown, Attorney Brown, this law, proposed law, has a section on page 3 that says that this determination regarding responsibility is not public information. What's your opinion of that? Page 3. Page 3, it's a continuation of subsection C, 5230. I'm sorry, sir, could you turn your microphone on?
So the question to section is right of non-disclosure. Trade secrets or confidential proprietary information furnished and identified as such by a bidder or offeror regarding responsibility pursuant to this section and confirmed as such by the procurement authority is not public information.
Right. What
as defined.
Do you think that's wise?
Well, it's accurate.
It's accurate, but I'm asking for your determination or opinion as an individual with expertise on procurement.
No, it's already in the procurement law as well as in that section, saying that trade secrets...
But there's nothing to prevent the legislature from striking it throughout the law. What do you think of keeping that information?
Trade secrets and confidential information?
No.
That's all we're talking about here.
No, I'm talking about determination of responsibility or non-responsibility.
So we're not talking about this last section C, right of non-disclosure now. We've moved to a different topic.
Right of non-disclosure, and then if we go to the next page over, page 3, and I would ask you to read, not to yourself, lines 1 through 4.
And shall not be disclosed. Outside of the GSA, Department of Public Works, Persons Agency, and made to be disclosed to the Attorney General.
Right. So my question to you is, should that information be kept from the public in general?
Yes.
Okay, why?
Well, would you like to disclose your customer lists, your costing, anything like that if you had a business?
Yeah.
And that's what we're talking about here. We're talking about trade secrets.
Well, okay. But it says information furnished and identified as such by the offerer or bidder.
Yeah, that goes...
Regarding responsibility.
Yeah, that goes to, it's GAR 3116 B2A4.
Yeah, sir, I'm confident you would be able to find it in the GAR.
Yeah.
So I won't put you to that task, but I'm asking you for your opinion. If a offeror or bidder is determined to be non-responsible, Should that information be disclosed to the public in general? In your opinion, I know the law is
In my
otherwise.
opinion, see, you have the right to ask them if they're a responsible person.
Sure.
Asking about their trade secrets doesn't determine that they're responsible. Ask them about their what was the other one, confidential proprietary information. That doesn't go to their, anything that says about responsibility. The factors of responsibility, that doesn't get involved in that.
Right, okay. Well, I think that we're having a difference on the interpretation of this proposed language. It seems clear that if an agency or procurement authority makes a determination regarding responsibility, that it is not public information. I would just put to you that it probably should be public information. And
Well,
I'll leave it
it's
at
already in the law that it doesn't.
Right, but
And if there is a provision in the,
yeah, you do recognize the legislature's authority to change the law.
I've been around a while, yes.
Yes, okay, all right. And if I can go to the public auditor on this one, I think there's a cap on the amount of time that a contractor can be debarred, and that is 2 years under Guam law. Do you think that's sufficient? Just a 2-year debarment?
You know, I don't know.
Okay.
I've not, well, I tried to do a debarment of a contractor, but that's in litigation right now.
Okay.
And I've not seen any other debarring. I'm not even sure if there's been a debarment in years.
I am unaware of it, and that was my next question, is have you ever dealt with a protest in your office regarding debarment, a determination to debar a, I'll throw that over to Attorney Camacho as well. I'm just wondering if it's frequent, is it a frequent procedure that you see?
No, and here's why. The statute and the regulations are messed up.
Okay.
It's a similar situation if you're familiar with the Pacific Rock cases by the Supreme Court, okay, where they, there was a portion, somebody, and this is decades ago, just said, okay, the procurement protests will be determined in accordance with the provisions of the Small Claims Act or something to that effect.
Right, yeah.
Somebody just threw that in there without harmonizing that particular procedure with the procurement protest procedure. No, I think he was still a judge at this time. This goes back.
I think the public auditor was actually on that opinion.
Maybe.
Hawaiian Rock 1 and 2?
Yeah, maybe.
That made everything clear as mud.
And so what the court did to clear that up was they just said, so the small claims procedure doesn't apply. We're going to follow this procedure, instead, the procedure we're using today. In like manner, way back when, where somebody just said, so there's this really detailed procedure that we're supposed to follow to do a debarment, which includes notice, a hearing, so on and so forth. And then somebody just threw in a later amendment to that, I believe it's in the, I don't know if it's the law or the reg, I want to say it's the law though. Oh, the Administrative Adjudication Act applies and nothing further. And if you read the notice provisions and the hearing provisions in the law and the regulation, they conflict with the notice provisions of the Administrative Adjudication Act. There's no harmonization, and there's no Supreme Court hearing like there was in Pacific Rock to clarify that issue. So that's why if you're looking to debar somebody at the agency level, you come into that morass and you decide, maybe we'll just not do anything, okay? And that's why you're going to see, as hinted by Senator Joanne Brown earlier, these protesters who file a frivolous protest, really, who do it over and over again, and there's really no penalty. It's supposed to be the debarment, but because that's messed up, because that's there, and there isn't a case from the Supreme Court clarifying which procedure applies, you're not going to see many debarments. Thank you.
Could you provide us a memo just on that issue, on how we could fix that, I think debarment is very important. I don't think we use it at all, and we certainly don't use it enough. But, and then just bill it to your agency, I'm sure that won't be a problem.
Well, no, I basically,
Right.
I can provide you with that section of debarment that I provide for my procurement modules for GCC when I teach procurement. I also teach
Right,
as-
but with your recommendations on how to clean it up.
I'll see what I could do quickly.
Okay, yeah.
But,
I mean,
that is a,
yeah, we don't need a brief, just, one page. And then Attorney Camacho, I'm going to ask you, I'm going to stay with you on this one. You were talking earlier about licensures and the requirements of licensures and how it might disadvantage, I suppose, an off-island competitor. If an agency has determined, because procurements in theory are supposed to be planned, if an agency has determined that you need a license to do this, and you must respond to the request for the license, why shouldn't we extend Chevron deference to the agency and say, well, they're the experts, they know, so we should step back?
I can't think of a case at the Superior Court where by the time it gets to the Superior Court or the Supreme Court, there's really no Chevron deference because the public auditor, by statute, has deference for their opinion, which is what's usually up for review.
But should we not defer to the agency's determination as well?
In terms of the agency making that determination, it is the one entrusted with making the determination of responsibility by statute and by regulations. It's the agency who's going to determine whether or not a bidder or offeror is responsible. So that's who gets it by law. Where this issue comes up is, and it's kind of interesting because, Guam's a small community, and so you got bidders, and they'll all go up there, and somebody will say, you'll get, some protest saying, oh, this person is under investigation by the feds. And it's not even on the news. And lo and behold, you dig into it, and guess what? Hey, it's true. Okay? And that might affect a ruling on responsibility. Likewise.
But I guess my question is,
yes.
when the agency's putting together specifications, and they make a determination that we need this license or that widget or whatever, shouldn't we defer to the agency's determination that they need that license?
That would be correct. And whenever you see a procurement, a construction procurement that really specifies what licenses are needed, that's usually prepared by a consultant,
right.
Usually an architect, engineering firm.
Sure.
That would have the expertise to say, hey, to pull this off, you need X, you need A to Z or whatever it is. So the issue that we might have, as pointed out by the superintendent,
Okay.
is dealing with the contractor's licensing board, because that would cause that would take additional time, and that would cause, I only see that causing further delay. That's the other issue.
Okay, and then just real quickly, I'm going to move back to the public auditor. You may not want to answer this question, which I totally respect. If a protester the protest is based on specifications, I think it's just too onerous, and why do we need this license? It's not necessary, and so forth. In the execution of your office, would you generally defer to the agency's determination on that?
If the agency has determined that a specialty license or anything special is required and it's in the bid, I'm going to comply with the bid.
Okay, so
And the problem is that some of them don't have the expertise to know that that's required.
okay, and I think that that's very true, but my only observation would be that procurement's supposed to be planned.
Yes.
And if the agency's failing at that, then they are failing at planning their procurement.
And you're right, that a properly planned bid should have listed those licenses and listed it as a requirement up front and not have to wait. And regardless of what the GAR or the law says, say that as far as we're concerned, in order to be responsible, we require this.
Okay, and I think that it is appropriate in almost every circumstance, just an editorial comment, I think it's appropriate to defer to the agency's determination. But anyway, and then just one more, substandard performance, as everyone in the room knows, is very expensive. Substandard performance is expensive for the government of Guam. If somebody is not getting it done, and they haven't gotten it done, I think that should be a factor in determining responsibility going forward, more than just for 2 years. If they're not getting it done, we don't want to hire them to do another botched job. I see that Attorney Brown has a comment.
Yeah, it's one of the factors in the regs for responsibility. Do they have a record of performance?
Mm-hmm. Yeah.
A good record.
A good record. Should we tighten that up and instead of just saying, ABC company is debarred, should we say, I don't know, the owner of ABC is debarred as well?
They're not debarred just because one time you have to go through the process of debarring them, but that is also one of the reasons for debarment is that they have had recent non-performance issues.
Okay. All right. Thank you all for your responses. Ma'am, thank you. Thank you, Chair.
Thank you, Senator Fisher. Senator Taitigui.
Thank you, Madam Chair. The bill is pretty much straightforward, so, and questions were asked. I have no more questions, but I thank you for being here this long. Thank you.
All right, thank you for your stamina today. If there are no further testimonies, bill number 45-37 has been duly heard. So now to our next item on the agenda, Bill 46-37, COR, sponsored by myself, Senator Sabina Flores Perez, and Senator Chris Barnett. It's an act to add a new section 5425.2 to Part A of Article 9, Chapter 5, Title 5, Guam Code, annotated, relative to providing temporary expedited procurement protest procedures for acquisitions funded with American Rescue Plan Act monies allotted to the Guam Department of Education. Again, I'd like to acknowledge my colleagues that have joined me here today, Senator Jesse Lujan, Senator Chris Barnett, Senator Tom Fisher, and Senator Tello Taitigui. So a brief introduction. Bill 46-37, co-sponsored by Senator Chris Barnett, is the second of 2 bills on today's agenda that proposes an expedited protest procedure for capital improvement projects, particularly for the Guam Department of Education. GDOE's 10-year facilities master plan, which guides investment in our schools, identified much-needed construction and modernization work and estimated the deferred maintenance throughout our public schools. And this decades-long deferred maintenance has resulted in deterioration of aging facilities and an urgent need to repair existing or construct new facilities to ensure the safe and healthy learning environments. GDOE has been provided a once-in-a-lifetime opportunity to utilize a portion of the federal funds through the American Rescue Plan Act for capital improvement projects, which is approximately $100 million. Additionally, provided that there are no extensions, the timelines to obligate ARPA funds ends December 2024, along with the opportunity to accomplish deferred but urgent capital improvement projects. Although protests are an essential part of the procurement process, Guam's current protest process can often lead to lengthy delays in procurement and can potentially lead to inability of GDOE to expend funds within the required deadlines, or can lead to their inability to secure the best possible procurement costs to the people of Guam, or to undergo urgently needed facility improvements. Bill 46-37 aims to provide a temporary expedited procurement protest procedure for capital improvement projects funded with ARPA funds allotted to GDOE and enable them to complete much-needed projects for the well-being of our school and faculty. I thank my colleagues for their participation and look forward to the discussion. For the record, no fiscal note has been received at this time. And so we have, I'd like to recognize Public Auditor B.J. Cruz if he has any testimony.
Thank you very much, Madam Chair and committee members. Thank you for the opportunity to provide testimony on Bill 46-37. The Guam Office of Public Accountability supports this bill as we understand the urgency to expend ARPA funds by December 2024. We have already, the office has already had the same expedited procedures previously in place for procurement funding by the ARRA. There were 2 specific procurement appeal protests related to ARRA that were successfully resolved within the 20-day period expedited appellate timeline. And I'm sure Mr. Camacho can take credit for that. He was the hearing officer at the time that moved those through. And we would recommend that all prospective bidders be notified upfront in the procurement solicitation that the procurement is funded by ARPA and that any procurement protest will be taken through the special expedited procurement protest process. In addition, OPA will develop and promulgate the rules and regulations for the special expedited process within 90 days, but it can be shortened again. And thank you. That's my testimony.
Thank you so much, Public Auditor. I'd like to recognize Attorney Camacho for his testimony.
Yes, this is a very, as I stated in my earlier testimony on the very first bill this committee looked at, one of the solutions is just amending the automatic stay. But going back to this specific bill, this is something with a very successful precedent. Back in the I want to say it was 2009, 2010s, we had the ARRA funding. And with the ARRA funding, a lot of that went to our public schools. The problem we were having is same thing as hinted by or stated by Senator Joanne Brown earlier. A lot of contractors were like, if I don't get it, nobody else will. And so they would protest and try to prolong the thing to the point that this federal funding, which had a deadline, if we didn't obligate it, it would go away. Literally tens of millions may have been lost. So the legislature passed something very similar, if not nearly identical to this back then. I was a hearing officer with the OPA, and it worked. A little bit about those particular protests, and I do have to state this because that was the last time we had major federal funding. The second time was when we had the ARRA or the ARPA funding that we have now. I'm kind of seeing a similar pattern where you get people who don't normally, or entities that don't normally submit bids for procurement, or not many of them, suddenly, when we have these federal dollars with the timeline, you'll see them come in. It's my opinion, a lot of them are doing it for the purpose of protesting and holding it up. And what they're trying to do is get the agency to settle with them. And it's like, well, I didn't get it. Here's my protest. It's rather frivolous, where they don't understand the law. But what they're looking for is the agency that's pressured to expend the funds will say, look, what'll it take? Will you settle for $5,000? It's usually $10,000, $20,000, and that's really what they're trying to get. That's where they're going to get their money if they don't get a contract. So they're purposely, in my opinion, some entities are nefariously abusing the system and holding it up. It is a law like this that kind of broke through that over a decade ago. And it's now that we're coming to probably the final deadline in the end of this year, I believe, based on that earlier precedent, this law will succeed at allowing us to use those federal funds instead of losing them because the whole process is tied up with the automatic stay and these frivolous protests. Thank you.
Thank you, Attorney Camacho. Attorney Brown?
Thank you, Madam Chair and Senators. I remember the ARRA debate when it came up, and they just wanted to have no obstacles at all, and they're going to get a lot of money to spend, however basically they wanted to spend it, which is what we're up against right now. And at the time, I characterized it as a take the money and run amok bill. Well, it didn't turn out that way. With the guidance of OPA and Mr. Camacho, it was there were no headlines. It was just somehow we went through it and did all the right things. So I don't have any objection to this.
All right, thank you. And now to the smiling acting superintendent. You're recognized.
Thank you very much, Madam Chair. Thank you very much as well for introducing the bill, Senator Barnett. I appreciate that. We definitely at GDOE fully support this bill, as it will ensure that ARPA monies allotted to GDOE will not be lost as a result of procurement protests. In GDOE history, the stays of procurement have resulted in great financial losses to the department. However, GDOE recognizes that the right to judicial review, and normally not going to get this from me, but I think it's important, in the procurement context is absolute. GDOE suggests that to strike this provision from subsection B, and we suggest that the remedy would be to put a limit again on the time frame, because we don't want it to sit there and get lost, of the stay itself, to ensure that the judicial processes do not stymie the use of the ARPA funds. In addition, on page 2, line 1, where the timelines to obligate should, if you can, strike that and replace it with expend. So it's not to obligate, but rather to expend the monies by December 2024. And although I know we are addressing ARPA monies because they will expire in December of 2024, I'd just like to share with you, if I may, that we do have other grants that I have learned, having been in already now for, say, 14, 15 days, that there are other grants that are expiring. If I may share with you, is that the Head Start grant definitely would expire on June 2023. The Education Stabilization Fund also will end in September of 2023. Our consolidated grants also will end in September 2023. So some they would allow for carryover, but then Head Start, we definitely need to expend it. So our procurement office is moving really fast to get big items out so that we can expend that money even before June. So we are inputting a lot of the information. So we're doing our part to be able to make sure we expend these federal dollars before they expire. My fear is, and this is what we're hearing, that Congress intends to not allow for carryovers, that whatever monies are not expended by the expiration date, that they will not then allow for a carryover. So, and that's our fear. So we are feverishly, and following all the procedures as well, spending these monies on big items. So when we talk about the ARPA monies, just to let you know that they are strictly to be used for the repair or renovation of all our school facilities. So these are big projects. Nothing like this, the lowest amount I can share with you, like for example, doors and frames is already at $6.4 million. So, and then it increases, with the other projects such as canopies at 8.9 million, electrical 9.8 million. So they would definitely, we would be able to use the monies and expend the monies. I met with the Guam Contractors Association, just to let you know, because I know we get that same feeling that contractors want to protest because if they can't get it, no one else can. So I'm meeting with the Guam Contractors Association as well to let them know that companies not working on the base, that there's enough money for all of them to be able to repair our schools, and asking them to please not protest. They should all be able to get a piece of the pie. And by doing that also is we want to break it down by region, so it's not just going to be one big project and these big companies will be taking all of the money. So we're trying to find a lot of creative ways to also help our community in a sense, but at the same time, to help us. And please don't protest, because ultimately the children will lose. And thank you again very much for this bill.
Thank you so much, Acting Superintendent, for sharing the the efforts that you're doing to make progress, considering some of the challenges that you face, many of the challenges. So at this time, I'd like to recognize Senator Tadigui. I know she has a time.
Thank you so much.
constraint.
Thank you, Madam Chair. I have a resolution to present and to one at 12:30. So I just wanted to, actually, this law is very similar to Public Law 31-12 that was implemented on March 9th, 2011 that Attorney Camacho was mentioning about. In fact, I reached out, Madam Chair, you know, as I discussed this with you, this particular bill, and found an opportunity on how we can, you know, make sure we obligate this money before the deadline of ARP funding. And it was a phone call I made to the OPA's office, who actually, we talked about this and reminded me of the ARA funding and how in 2011 this bill was passed, and it definitely provided the need for Department of Education or other agencies that receive the funding to expend this, and it actually is proven to have been done. So bringing this, Madam Chair, to your attention, you know, I hope that, I just wanted to thank the OPA, you know, for bringing the suggestion out about Public Law 31-12, and I thank you so much for always taking my call to the OPA's office. I think this is going to be very helpful. What you mentioned, Acting Superintendent, about the grants, I'm just saying there, I don't know if we can incorporate something like this with it unless it's ARP funding. But one question I did have is, do you see that in the event you have anything over $5 million that you can avail yourself? I mean, which has more power, this bill 46 or bill 36? I mean, you're able to avail yourself with both easily done?
Actually, both will help.
Very
because-
helpful?
Yes,
Okay.
because like I mentioned
And-
earlier, the doors and frames is
Right.
over the 5 million, so, and
Okay.
this one is 6.4
Well,
million.
Yeah, and I think this one here, other than Bill 46, just limits you to ARP funding.
Yes, I understand.
Right, so that
But I
Bill
also,
36, you know, 46, but Bill 36 does not. Okay,
I
Exactly,
absolutely
agree.
understand the
Okay.
process, but I just
Okay.
have to mention it, that it'll
Okay.
be part of the public hearing, so in the time of your markup, you may want to consider it. Thank you.
okay. Other than that, Madam Chair, I humbly ask to also be a co-sponsor of this legislation too as well, and appreciate the opportunity to be here. Of course, Mr. Brown and Mr. Camacho, attorneys, thank you for your time. Bye-bye.
Thank you, Senator Tadigui. So yeah, the question I have, I know we have two options here, and can they coexist? Do you believe, I guess, or is it probably worth just amending one of the bills, let's say the Bill 36 to, I mean, can it encompass, is there an overlap, or can they coexist?
In the details, there are some misses. I mean, there is some overlap too. So it would take a little bit of fine chiseling. But what's the harm in having both of them?
Thank you for that response. Public Auditor?
I can make them both work, okay? And I think you know the two of us have a long relationship. And she was needling me the other day because she went back on the legislative history on 3112. And I was one of two no votes in that. And the reason why I voted no at that time was because I had just come off the bench and objected to the judiciary being deprived of the authority to review the appeal. We didn't discuss this testimony, and I'm surprised that she brought that back in as a suggestion, because if you note, I was willing to live with the bill as it is, because I was surprised when I read the decisions that Mr. Camacho wrote for Doris back in 2011 and 2012, that it was very specific in the last paragraph that there is no appeal to the Superior Court. And there were no challenges to that. And since there were no challenges, I was willing to live with it and forget the fact that I, at one point, own a road. So now the thing has turned, and I don't know why she made that recommendation for judicial review with time period, because the ARA fund worked well, that there was no major constitutional challenge to the fact that the judiciary was denied the appeal process.
And I made that suggestion only because I wasn't aware that that was actually in that last paragraph, but I will withdraw my amendment, my request, and stick to what Attorney Camacho and OPA has suggested.
Right, thank you. All right, I know the differences between the bill, I guess, is an opportunity to compare the two, right? So the first bill, 36, doesn't have a sunset provision. It's more, it codifies it. So it does allow for that alleviation. Whereas this bill, there's a timeline. And you were suggesting that maybe there are other things, but it falls within, it seems like it falls within the 2024 timeline, but perhaps including other federal funding.
Yeah,
So
because
that's-
they would have to be mentioned so that we can make reference to it in terms of expediting then the procurement, but they would expire before December 24.
Okay. Okay, well, thank you for that. We'll definitely, the committee will consider those recommendations. Thank you. So I'd like to open up the floor to my colleague, Senator Lujan.
Thank you, Madam Chair. I yield.
Masi, Senator Barnett.
Thank you, Madam Chair, for the opportunity to co-sponsor this measure. I know that when we had a roundtable and just in a lot of discussions with various education stakeholders, they always talk about procurement problems and specifically the protests, but you really made our work easy for us, and that your public law is kind of like the model for expedited protests. But I would just like to ask Attorney Brown, so Dr. Wampat had mentioned other funds, the Head Start, ESF, consolidated grants. I just want to ask, what's the danger of applying this expedited process, in more areas? And why would you, if you would, caution against it?
Senator, thank you for the question. As I said before, these things spread. And then before long, you're going to have that same thing in your run-of-the-mill IFB. So the subject matter, if you just let it spill overboard, everybody's going to want it. It's just the way that works here.
Dr. Wampat, yes?
If I could explain, I'm not asking for this for forever.
Right.
I'm asking for this now because we had committed several ARPA monies that now we're moving into consolidated grants. We're moving them over to the Education Stabilization Fund. And by doing that, it means, of course, that it has increased the number of procurements that they're going to have to go out. And because of their expiration date, we need to expedite that. But normally, CGs do carry over. But for this particular $20 million that I'm trying to use as I transfer, redirect monies from ARPA to CG and ESF, then has to be expedited at the same time with the ARPA monies. Head Start's a little bit different. They stand alone. And because we were visited by several federal individuals have told us about some of the violations that we needed to do and to expend these monies to before they retire. So that's the reason why we're moving with this even beforehand. Even if you didn't give it to us, let's say, for Head Start, we're definitely quickly moving to expend those monies.
On that note, you said June 2023, right?
Yes.
Is that reasonable to expect that you guys could expend those funds?
No, that's what it is. So that's why I'm saying the way I've set this up right now with the division heads is that I'm making facilities a priority for all requisitions to be inputted. And that's for everyone in the department, because just think of it this way, of a funnel. Everybody, all the departments, all the programs, all the divisions rather, are putting all their requests in, and you got that tiny funnel in the bottom, and then, you know, they all get bottlenecked there. So our approach now is that all procurements for and requisitions for facilities will go first in the first 3 weeks. Then thereafter, then you'll be contracts and bulk orders, and then other emergencies such as this Head Start will move to the top of the list.
Okay, well, if you, I mean, after the hearing, if you have a list and the different deadlines, just send it our way, and if we can amend the bill to include those with those timelines in place and not let it last forever, then I'm pretty sure that we'd be willing to do that. And I think you know, there's all these different procurement bills. I always joke with Madam Chair that, you know, procurement is definitely not sexy, but I like it. And I think that our intent with a few of these measures was really to assist the Guam Department of Education, because I know that we're the public, as well as, you know, some of my colleagues in the body are in the process of trying to set some deadlines and some, you know, some hard pushes, but we also want to enable you guys and give you the tools that you need to go out and do the job, right?
And just to, you know, bring back confidence again, you know, in our community, businesses, you know, yourselves as well, is to know that we are working with US Ed on the transition of our third-party fiduciary agent for us now to take over, and this has to be approved by them. So they're reviewing a flow chart for our procurement, you know, and ways to ensure that we are following what was originally required of the third party, or is still required by the third party fiduciary agent, to now then transfer that to us to do for not just our local funds, but all federal funds, such as, you know, the Consolidated Grant, Head Start, now with ESF and ARP.
Thank you. Attorney Brown, so this bill's for protest procedures, acquisitions funded with American Rescue Plan Act monies allotted to the Guam Department of Education. Would you, or just what's your advice on having this apply GovGuam wide for ARP funds?
I'm sorry, what was the end of that?
What is your thought on having this apply government wide relative to the protest procedures for acquisitions funded with ARP monies outside of GDOE?
It's good for the goose, is good for the gander, but as long as it doesn't go over those, you know, if you identify it and it's all there and you're gonna get the money from ARPA,
right,
or you fully expect to, yeah.
Because if GDOE is concerned and wanted us to address this issue, I can only assume that there are probably other entities in the government of Guam that probably share the same sentiment, right?
Yep. Maybe
Public
we'll
Auditor?
build a hospital with it.
That was an excellent question, Senator, because if you read the transmittal letter from the governor on 31-12, he says his disappointment was that the legislature didn't implement the bill 48 as was originally introduced, which was government-wide. For some reason, we struck everything except for GDOE. And the governor said, I'll sign this because it's good, but I wish we had left it in for everybody else because we also have ARA funds that we need to expend.
Right. So what are your thoughts, Auditor, on having this apply government-wide relative to ARP funds?
I would support it.
Okay.
Yeah, I mean, because when I read that transmittal letter,
right,
and as long as there was no constitutional challenge to depriving the court, I'm fine. I like being able to put this no right of appeal.
Doc?
I totally agree. You remember I was the oversight chair for education, and my concern was to get out those ARA monies. And that's true. The governor admonished me for not including all the departments and agencies. but I do know for a fact that there are other departments and agencies who also have access to these monies, and they're all going to expire in December of '24. So yes, if it would help others, I would definitely share this with all the different departments and agencies to benefit from this legislation.
Thank you. Thank you, Madam Chair.
All right, thank you, Senator Barnett. Senator Fisher?
Thank you, Madam Chair. I noticed that the legislative findings and intent states that I guess I'm going to direct this to you, Speaker, that the American Rescue Plan Act is for capital improvement projects. Whatever the instrument was that transfers ARPA or potentially transfers?
No, so the way it works is that when they give us these grant monies, they would ask us, I mean, they tell us what the parameters are, so then they'll ask us, what do we want to use these monies for? And prior to my coming into the department, some of those monies already were used, for some individuals that were hired that are placed out in the schools, some PPE, some materials for the nurses. It was actually at the request of the legislature also to use $16 million for utilities. So all that had to go to US Ed to request for those individual expenses. However, in my conversation now with US Ed, they're liking the fact that we are redirecting some of these monies out to other grants that are allowed to expend monies on those activities or programs. And they like the idea that we want to use it now for one blanket project, which is facilities.
Okay.
And I'm sure you probably read the national news where a lot of now school districts are actually asking to do the exact same thing, to use the monies for their facilities.
Okay, so I gather then that any project that we think is appropriate will be filtered through some sort of federal lens to determine whether or not
Yes, so we'll be sending a letter to US Ed telling them that this is what we want to use.
Okay.
The remaining monies in ARP.
How much money is left?
Well, what is left after we have given the share to private non-public schools and also to the charter schools, it brought us down to about 180 million. But then some have been expended already, as I said earlier, like for example, 16 million for utilities. So and I know that.
So I'm sorry to interrupt, but in the bank right now, we've got somewhere in the area of 180 million?
No, it has come down already. Like I said, we paid 16 million for utilities already.
So now we're at 120 million.
You're right.
Yeah.
So, and then the rest of the monies we've been moving over so that we can actually, and my goal is to bring it up to a certain amount to be able to address all of the school facilities.
Okay, and then I support this bill.
Thank you.
And the reason I support it, I mean, you said the money has to be expended by the end of the
Expended
year.
by December 2024.
So not just obligated.
No, that's right.
We've actually got to write
Yes.
the check.
Yes.
And if we don't, the money goes back to the feds?
It goes back to the Treasury, U.S. Treasury.
Never to be seen again?
That's right.
Okay, well, that's not satisfactory. We need to, yeah.
I agree.
Yeah, we need to spend the money. And so just follow up on that. Are the procurements that you're anticipating, are they ready to go?
We have, excuse me. Yes, many, like I said to you earlier, we're using these timelines that we're setting for ourselves. For the first 3 weeks, all facility requisitions are going out. Okay. We have the scope of work because the engineer had asked us that if we identify these monies, and we have already up to a certain limit. I don't want to say how much yet because I don't want anyone to think that I'm going to go out and put out a bid for this exact amount because this is what you said. So.
Well, do you think, will you be able to spend that money?
Absolutely.
Okay, so you'll actually be able to write the checks.
I'm very confident that we can because, again, in my conversation, not just with the engineers, GPA is helping us, my conversation with the Guam Contractors Association, they love the idea when they found out these are federal dollars. Mm-hmm. They're now, I'm going to meet with some of the members themselves, not just the officers, but the members themselves.
In order to assist you, you know, there's a policy in procurement against advance payments. Yeah, and
No, that's the reason why I guess one of in this previous bill that you have, requiring them to have licenses, and certifications and all that, that they should be able to start off. See, the idea of why I'm feeling very confident about this is because we want to break it by the 4 regions.
okay.
And so that then all the work can be occurring concurrently, not waiting for one school and the next school, because then we will never make it. We'll go beyond the 18 months. But by doing this concurrently, then we shorten the time frame in which the work will be done.
Okay. All right. Thank you. Just one observation, I guess, is I'm sure that the public auditor is uncomfortable with this as me, but the idea of truncating a right of appeal or judicial review, I think it makes every attorney, well, everybody uncomfortable, but I certainly recognize that we need to spend the money, and I'm happy that you are confident you can spend the money. And the other thing I'd like to do, or like to say, is I'd like to compliment Senator Perez and Senator Barnett because they recognized a need that had to be addressed immediately, and they took up this bill. And ma'am, I'd like to be added as a co-sponsor as well.
Thank you very much, Senators.
All right, thank you. Thank you, Senator Fisher. Just a question for a public auditor. So if we expand this to all government of Guam agencies, would that, would you be overwhelmed potentially by, if we get overwhelmed with protest? Do you foresee that?
We could be, but if we need to spend the money and it's being spent properly, we'll address it somehow. I have 2 hearing officers, and if it's necessary, we'll have hearings.
Okay, good. Thank you for your support. And so again, with this bill, you would need a waiver from the Administrative Adjudication Act so that you can produce the rules and the regulations in a quicker time?
If you authorize me to, I have to follow the law.
Okay, great. Well, thank you so much for your here to answer questions and your testimony. We do have one more item on the agenda, but before I do that, so being that there are no other are there any further testimonies before I close on this? Okay. Hearing that there are no other testimonies for bill number 46-37, this bill has been duly heard. So now on to our next item of the agenda, Bill 8-37 COR, sponsored by Senator Jesse A. Lujan. It's an act to add a new section 5221 to subarticle B of Article 3, Chapter 5, Title 5, Guam Code Annotated, ensuring the online accessibility and timely posting of any and all Government of Guam invitation for bids and requests for proposals on a dedicated government website. I'd like to acknowledge my colleagues that are here today, Senator Jesse Lujan and Senator Tom Fisher. At this time, I would like to invite the author of Bill 8-37 for his introduction.
Thank you, Madam Chair. Before I actually read the bill and my opening remarks here, I just, for the sake of not having to pull the bill back and resubmit it with another bill, I will be making the amendment on the floor. Again, at the start of our term, there's 3 of us sharing offices, and we were working out of one computer. And the mistake we made was not adding, or in Section 2, subsection 5221, will be the what will be codified should this bill become law. So the only correction basically is that Section 2, subsection 5221 will be underlined. All of Section 2. A, B, C, and D will be underlined as the portions to be codified, and I'm glad the caning law is not in place right now. Otherwise, the chair would be I'll be the first one to be caned by the chair. But anyway, that being said, but thank you very much, Madam Chair. Again, thank you again for putting this bill for a public hearing and be discussed today. I introduce, of course, Bill 8-37 because in 2023, all RFPs and IFBs issued by the Government of Guam should be easily accessible online and found on one website. It's been long overdue. and it is the government of Guam's best interest to be as transparent as possible, as we all have continuously stated as such. Our local government should want as many competitive bids submitted as possible from the largest group of capable vendors and companies. This way, the government is most likely to get the best quality product or service at the most reasonable price. Right now, RFPs and IFBs are located in multiple places, and potential vendors can never know if they have missed one, which makes it a very challenging task or to track. Right now, all GovGuam public hearings and meetings are posted on one website on notices.guam.gov. Coordinating the web posting and publishing of all RFPs and IFBs can be done relatively easy. The current software and tech tools used for meetings and public hearings can also be used for RFPs and IFBs. This bill adds a new comprehensive and transparent option while keeping in place the current announcement methods. We are creating a more accountable and transparent process which will level the playing field for all potential vendors. The federal government has one site for most of its bids, and almost all states do as well. And it's time for the government of Guam to do as such, to do the same. Again, as the chair had read the act to add new subsection 5221 to subarticle B of Article 3, Chapter 5, Title 5, Guam Code Annotated, ensuring that online accessibility and timely posting of any and all government of Guam invitations for bids, IFBs, and requests for proposals, RFPs, on a dedicated government website. Section 1, of course, the Statute and Guam finds that as it currently stands, there is no official website in existence that may be accessed online by the public in regards to viewing all invitations for bids, IFBs, or requests for proposal, RFPs, in one place. Under the principles of transparent open government, this legislation is to establish the internet-centric public service for the people of Guam in regards to viewing all and any requests for proposals, RFPs, and invitation for bids, IFBs, that are announced by the government of Guam. Presently, there exists a website for all public notices spearheaded by the Governor's Office of Technology. This legislation adds a new section 5221 to subarticle B, Article 3, Chapter 5, Title 5, Guam Code Annotated, thus amending the Guam Procurement Law, and in doing so, amend by expanding the law to read that the Office of Technology shall create an additional web pages and sections dedicated to any and all invitation for bids and RFPs on the website notices.guam.gov on a separate website dedicated to announcing all our IFBs and RFPs with timely updates and maintenance of said announcement pages. The announcement shall be posted on the website at the same time as is posting on the respective agency's website and newspaper postings. And again, Section 2, Subsection 5221, Chapter 5, Title 5, Article 3, Subarticle B, Guam Code Annotated, is hereby to read as follows, and this will be underlined if what you're viewing is not underlined at this point. This will be the one codified should this bill become law. 5221, publication of IFBs and RFPs documents on one central website. A, the Office of Technology shall create and add official websites and sections dedicated to any and all invitation for bids, IFBs and requests for proposals, RFPs on the website notices.guam.gov, or a separate website created exclusively for the purpose of announcing all IFBs and RFPs with timely updates and maintenance of said announcement pages. These announcements shall be posted at the same time as the posting on the respective agency's website and the newspaper announcements. B, requests for proposals, RFPs, and invitation for bids, IFBs, are defined as requests open to the general public for proposals and bids to compete projects announced by the government of Guam. The present situation forces business and potential vendors to search for such requests and invitations in various places, while never knowing if they have discovered all bids. If it is the government of Guam's intent to acquire the best proposals and bids from all and any interested vendors, it falls short of its effectiveness. If prospective vendors and possibly the best vendors are hindered in their search and submission due to inaccessibility to public requests for proposals, and or missed deadlines due to delayed postings of announcements, then the current method of distribution must be improved, as it is in the government of Guam's best interest to stimulate a competitive market and to encourage a variety of alternative proposals for government selection and therefore the people of Guam. This legislation is to ensure that by creating one such central website or web pages, internet-based digital reference center that is easily accessible to the public and current to timeframes and periods, then we can ensure we receive the best proposals and bids for quality vendors. C, the manner of posting any invitation for bids, IFBs, and requests for proposal, RFPs, online shall be in accordance with Guam procurement law regarding subsection 5220 of subarticle B, article 3, chapter 5, title 5, Guam Code Annotated. For the sake of effective communication, this requires each posting to be accurate in information, precise to the purpose of the announcement, and timely in that each posting shall be accessible on the website no later than the same day that is announced by the government of Guam, as well as posted on the respective agency's website and announced in newspapers. The term timely also includes the speed and manner of updates pertaining to the status of said announcements. The web pages to be created and established in this legislation are in addition to and not instead of the current distribution methods. Therefore, the practice of placing requests for proposals and invitation for bids on the procuring agency's websites in this newspaper outlet shall continue. D, the development, creation, and maintenance of the aforementioned web pages referenced in this legislation shall be under the authority and guidance of the Government of Guam Office of Technology and executed in a timely manner on the website notices.guam.gov or a separate website established entirely for the sole purpose of posting all invitations for bids, IFBs, and requests for proposals, RFPs. Thank you, Madam Chair.
Thank you, Senator Lujan. So basically, the alternate version you have has the underline?
Yes, ma'am.
Okay,
Yes.
but the language is still the same?
The language is absolutely the same. The only difference is that it's underlined, and that would be the ones codified.
Okay,
Yes.
okay,
Yes.
I
And
appreciate that.
I would submit that in a session for as an
Substitute
amendment.
version?
Substitute version. Yes, ma'am.
Okay. All right. Thank you for reading that into the record. So just a little bit of background. Fisco note was received February 2nd, 2023. BBMR states that the proposed legislation is an act to add a new Section 5221 to Subarticle B of Article 3 to Chapter 5, Title 5, Guam Code Annotated, to ensure online accessibility of timely posting of any and all government websites, any and all government of Guam websites. The proposed legislation intends to mandate the Office of Technology to create and add official web pages and sections dedicated to any and all IFBs and RFPs on the website https://notices.guam.gov or a separate website dedicated to announcing all IFBs and RFPs with timely updates and maintenance of said announcement pages. Upon enactment of Bill 8-37, the Bureau anticipates that OTEC must arrange a contract with their current vendor to add specific pages reserved for IFBs and RFPs only. After reaching out to OTEC for comments regarding Bill 8-37, it was conveyed that it is possible to add an additional page to the notices.guam.gov. Currently, OTEC expends approximately $3,000 annually for the maintenance of this site. To implement this amendment, it is estimated the additional $2,000 will be required to add a web page specifically for IFBs and RFPs for the first year. It is anticipated that OTEC will have to absorb the additional costs as there is no appropriation contained in Bill 8-37. Okay, so just some questions to the, I'd like to now open the floor for any testimony on Bill 8-37. Attorney Brown, you're recognized.
Thank you. Do you understand what an invitation for bids is?
I'm sorry?
Do you understand the complexity of an invitation for bids? That phrase that you're going to be putting on a website? It's going to have you doing something with the same invitation for bids because it includes all the documents It includes everything that happens throughout the life of the contract. Do you have the staff for that?
The Office of Technology. I'm not finding a way for the government not to do things. I'm finding a way for government to do things,
Right.
and on more easy accessibility.
Yeah. And it's not another unfunded,
I'm sorry?
it's not another unfunded obligation of that.
No, they notice the fact that they would absorb the funding, and if $2,000 needs to be made, then I will make that amendment on the floor.
Yeah, okay, it just struck.
It's
a good thing to do.
To not be able to want to do something like this just gives the People's House the view that maybe things don't want to be as transparent as possible.
Yeah, that's possible.
That's possible, yeah.
If you set out to do it and they fail miserably because of the obligations that they have to do
Well,
this
they're already
timely.
they're already doing it in separate websites.
Yeah.
We're saying consolidated in one, in consolidated not just in their not just put it in their website, but to consolidate it in one website. So we're just going one, so it's easy for everybody to come and see. So it's already being done. You just transfer it over to Office Technology, and it's one website that has everything on there.
I'm not denying the utility of this and the need for it.
Sure.
I'm just, to me, it's a mountain that you got to climb. But I'm not a computer technician.
No, I mean, if you ask me if I'm the one to be able to do it, no, I'm not that tech savvy to be able to do something like that. But that's why it's called, I guess, Office of Technology. And so, I mean, federal government can do it. We can do it as well.
All right. Thank you.
Thank you.
I have no problem with it.
All right, thank you, Attorney Brown. Public Auditor, B.J. Cruz.
Thank you, Madam Chair and committee members. Thank you for the opportunity to provide testimony on Bill -8-87. The Guam Office of Public Accountability wholeheartedly supports the intent and expedited passing of this bill. The only recommended amendment we would like to make is that the OTEC be instructed to include a visible time and date the post was updated onto their website, so that when you Photoshop that page for the procurement record, it shows that it was posted on this. I'm not sure if they have the date and time, like when you have your emails, so that they know that it's exactly the same day that it was posted by the government agency and it was posted in the paper, or whatever all the instructions were. Just make sure that whatever time they post it, it's there so that people can say, I saw it at 12:45 on the 23rd of December. February. But we wholeheartedly support it. It's the 21st century.
All right, this is Masi, Public Auditor. I'd like to recognize Attorney Camacho.
Yes, I'm also supporting the passage of this bill. I think it's a great idea to consolidate them in one place. There's just a couple of minor amendments that I would recommend. The first being, I understand that the intent is that the posting on the additional website would be in addition to the posting on the agency's website. The language that concerns me, though, on page 3, lines 12 to 18, where it concerns newspapers. So we do expend hundreds of dollars for every IFB or RFP just to publish it. In accordance with Guam procurement law, that's already required. I would recommend additional language be put there to say that nothing herein shall require an additional newspaper publication of the IFB or the RFP beyond what's required in Guam procurement law, or something to that effect, just because it would be duplicative and unnecessary. I believe the intent is we're going to publish it in the newspaper like we're supposed to, we're going to publish it on our website like we're supposed to, and then we're going to publish it on this new website as well. The second amendment has to do with amendments. So I believe if it's already going to cost $2,000 just to put the IFB and the RFP up there, some solicitations have several amendments, in particular time for submission of bids or offers or so on and so forth. You might want to, they might want to have some language in there stating that either we post the amendments on this one website as well. I don't know if they're capable of doing that, or just post the initial IFP or RFP there and say, please see the agency's website for any updates or amendments or something to that effect, so they don't think that it's still the same way here. But we go to the agency website, there's like 5-6 amendments that have either canceled the solicitation entirely or extended the timeline to submit bids or offers. Thank you.
All right, thank you, Attorney Camacho. Acting Superintendent Judy Wampat, if you have any testimony.
Thank you very much. We actually have the same concerns as well. We do not mind having one central website, but I'd like to say, so we just wanted to make sure that that Office of Technology is also separate and apart from what we put in our website. So we're saying that GDOE would still retain the responsibility to publish in print and also on our website, and set by the deadlines that we have imposed on ourselves. But what we suggest then is that the Office of Technology would be that we would transmit, after we published it on our website, that we would transmit then the solicitation to publish on their website. So we just want to make sure we don't go to the Office of Technology first to give them the information before we even do it. We want to be able to put it on ours, and then we will then submit that as well to the Office of Technology.
Yeah, it'd be just basically what you're posting in your website.
Yes, will be reflected. Yes, exactly.
Yes, yeah,
okay.
yeah.
Thank you.
All right, thank you for the testimony. So I just would like to offer the sponsor if he has any questions to the panel.
I don't have any questions. I think it's self-explanatory. Thank you, Attorney Brown, for that. And again, as Attorney Camacho had stated in regards to that, then we can also reference that these IFBs are to refer back to the agency's website where that's all contained. But it's basically, this one here is just to show that this is what's up. This is what's up for IFB or RFPs. More information, boom. Go to this website, click and go to this website. It'll take you there. But thank you very much. That's very helpful, because that could, you said, like you said, could be hundreds of pages. And but I'm sure the agency in charge would be ready for that. So, but
It's probably like the backup that you have on your own computer to make sure you got the same files
That's
at
right,
home.
that's right.
So it goes in there and it's over there already.
That's right. That's right. Yeah. And Attorney Camacho, thank you very much for that input. It's very valuable, and you're much more versed in this, and we just want to make things a lot easier for each and every one of you, and hopefully we lessen the protests. I don't think it will, but anyway, our attempt. Thank you very much, Madam Chair.
Thank you, Senator Lujan. Unfortunately, we have to take a quick reset. It's 12:45 to give AV time to reset, so a brief recess.